Let's see.
We are live.
Great. It is February the 4th, 2021. Welcome to the House Judiciary Committee. We have 4 bills that we're hearing today. They are all going to be under what we call the 3 and 2 rule. That means the sponsor will get 3 minutes and the witnesses will each get 2 minutes to testify. As I mentioned, we have 4 bills today. So while we don't have very many bills, I think there's one piece of legislation that has a few more witnesses than the others. Witnesses should keep themselves muted until the time when they're called upon to speak, and then they can unmute themselves. Same things for members of the committee. Delegates McComas and Williams, you are not muted, neither is Delegate Lopez. So to that end, you should stay muted until I call on you, just so that we can keep the amount of background noise to a minimum.
Can you unmute me without me getting out of the system to look up?
Oh, I see. We can.
Yeah, I already did that.
Okay, that's fine. So we'll try and mute Delegate McComas. That would be helpful. All right, and thank you all very much. With that, we're going to start with our first bill. It's House Bill 646 and Delegate Valentino Smith. There are 4 witnesses, including the delegate. The delegate will get 3 minutes, and then Caitlin Fissette-Eckert, Jody Pallett, Christopher Arnold will each get 2 minutes after that. All right, delegate, if you'd like to begin, we are ready for you.
Thank you, Mr. Chairman, members of the Judiciary Committee. Because of my 3-minute limit, I will have to limit all the compliments I have for the committee and how much I miss you and my time there. House Bill 646, Child Abuse and Neglect Memorandum of Understanding with Military Family Advocacy Programs. What it does is it creates a really clear pathway for the sharing of information between our local county health departments of social services and U.S. military installations. And they have programs called FAPs, Family Advocacy Programs in Maryland. It will require the development of an MOU between the local services departments and the military bases regarding child abuse, neglect, and violence allegations. Military installations are required by federal law to establish these FAPs, and they're required by federal law to coordinate with the civilian social service agencies to obtain information on allegations of abuse, neglect, and domestic violence. Currently, we've got a lot of inconsistency with the MOUs. Some exist in most of the jurisdictions, but they're different, and there is a particular jurisdiction that doesn't have an MOU right now in Harford County. So this will ensure that we've got the statutory intent for it. 70% of military families live off the military base, and they live in our communities. And so it's really likely to really be falling under the jurisdictions of our local family service agencies. So the establishment of a good communication chain is essential, beneficial, and necessary. The FAPs have come a long way. We had this bill in 4 years ago in 2017. The FAP programs are required by federal law to offer preventive measures, which include expanding public and general awareness, providing information, education, outreach, new parent support programs. They use trauma-based services and are required to train all their personnel in child abuse and domestic violence. They do rehabilitation, victim abuse. They work with potential perpetrators in different families. They do evaluations of family need. So referring or making sure that these cases, there's good communication between our local service departments that are dealing with these allegations and cases and coordination with the military installation where the person is a member of the military service is essential so that the FAPs can do their federally required work, which is preventative, rehabilitative, and treatment. And dare I say, in the case where it is significant and a significant finding for military purposes, it's really important that the military understand and know about these types of cases. They're not being referred consistently, which is part of the problem. There shouldn't be any hesitancy in the referral process because military action is strictly and expressly not allowed to be adverse or taken against somebody just based on an allegation or just based on an incident report. And that's what the military's evolved and come a long way with wanting to know about treatment and rehabilitation and not have the reputation for being punitive. And federal law has set up all of those requirements.
All right, thank you, Delegate. If you want to wrap up quickly, we'll go to your witnesses.
Thank you, Mr. Chairman. 4 years ago, there wasn't the robust thirst for prevention, teaching, and all that in this area, and I brought the bill back because I believe we're there. You guys knew that Harold Cooney came with me all the time because these are bills that are the priorities of DOD along the East Coast, and I'm proud to say that Harold retired, but today I have Christopher Reed, and so this is his maiden voyage here in Maryland. On behalf of the Department of Defense, so I hope you'll welcome him and he'll introduce the rest of his panel. Thank you, Mr. Chairman.
All right, so we're going to go then to Christopher Arnold, that is the State Liaison Office.
Yes, good afternoon, Mr. Chairman.
We'll go there for 2 minutes and then the next 2. Thanks.
Roger, good afternoon, Mr. Chairman, and I'm joined today representing the service, Major Eckhart and from the Air Force and Jody Pallett from the Navy, and they'll introduce themselves. Honorable members of the Judiciary Committee, the DOD is grateful for the opportunity to support the policies reflected in House Bill 646. We hope that Maryland will join the 27 other states that have passed similar legislation on this issue. Even one child's life is worth the effort. DOD relies on working in collaboration with state and local governments to fulfill its statutory obligation to address child abuse and neglect. The bottom line up front, particularly for those who do not know the military way of life, is that unlike civilian employers, the military services have the obligation to know what is happening with our service members and families 24/7. It is part of how we do business. Being a soldier, sailor, airman, marine, or spaceman is not a 9-to-5 job. Information sharing between DOD and local authorities must be accomplished at the start of an investigation, not after adjudication. Federal rule establishes policies and assigns responsibilities for addressing child abuse and domestic abuse through the Family Advocacy Program, or FAP. Formal MOUs between FAP and its counterparts in the local civilian community benefit victims by improving coordination on child abuse and domestic abuse investigations. House Bill 646 protects victims and achieves the DOD best practice of having caseworkers ask clients if they are associated with the military, helping connect victims that are identified as military affiliated with the appropriate FAP rehabilitative, preventative, and other services. Currently in Maryland, the present framework relies on individualized local MOUs to guarantee communication between county DSS and the military community. An exhaustive review of these MOUs indicate that they are inconsistent or fail to meet the requirements set forth in federal law and policy. The legislation before the honorable delegates today was last considered in 2017, as Delegate Valentino Smith indicated, and it was held apparently because every solution other than APG had an executed MOU in place, whose agreement was soon to be finalized. We now know that wasn't entirely accurate, as NSA Bethesda still does not have an agreement in place. And ultimately, the situation at APG has become instructive as to why a statewide solution is needed. Merely having an MOU is not a guarantee that it has operationalized communication and cooperation. 4 years has shown the ability of the FAP to offer services and manage consistency of information when families are transferred requires a statutory framework, statutory language, and statutory intent to ensure successful outcomes for the benefits of families and the intent of federal law and rule. DOD respectfully submits Maryland can assist the DOD mission to protect military children and other youth from abuse and neglect by enacting the policies set forth in House Bill 646. Mr. Chairman, we greatly appreciate the Maryland legislature has been a champion in addressing our key military family quality of life issues for the past 17 years. As always, as the Northeast Region Liaison for DOD, I stand ready to support where I can and thank Delegate Valentino Smith for her sponsorship.
Thank you very much. We'll go, I can see her, so we'll go to Caitlin Fissette Eckert first. And I can't tell what rank you are because Zoom isn't big enough on this computer, so I apologize for not referring to you by that. So go ahead, 2 minutes, please.
Yes, sir. Thank you for the opportunity to support House Bill 646. My name is Major Caitlin Fissette Eckert. I'm currently serving on active duty in the United States Air Force. As the Family Advocacy Officer for Joint Base Andrews Family Advocacy Program and a clinical psychologist, I'm deeply grateful for the relationship that we have with PG County CPS, which I do believe is largely been driven by the Air Force instruction requirement for a memorandum of understanding between our agencies. Working together as a community partners, we're able to address the safety needs of victims of domestic abuse and child maltreatment, as well as the needs of alleged offenders, other family members, and the community at large. Although I only took over this position in October of 2020, I've been thoroughly impressed by the open communication and seamless coordination I've experienced when collaborating on cases with social workers and other professionals from PG County CPS. We here at Family Advocacy have come to wholly trust their ability to manage risk, identify treatment options, conduct thorough home visits, complete child forensic interviews, determine appropriate supervision and placement, and provide extensive safety planning services. We rely heavily on their expertise and sincerely appreciate the support and guidance that they provide to our military families. Maintaining an MOU with PG County has proven invaluable in accomplishing our mission, and we look forward to continuing our strong alliance well into the future with the additional support and protection of the proposed legislation.
All right, thank you very much, Major. Now we'll go to Jody Pallett.
Good afternoon, Chairman. My name is Jody Pallett. I'm the Regional Counseling and Advocacy Program Supervisor for Naval District, Washington. I oversee 5 installations that are in Maryland. And I would just like to kind of simply and succinctly say that 3 of our 5, there are 5 Fleet and Family Support Centers that have family advocacies that are located within the state of Maryland. Presently, 4 of the 5 have established MOUs with CPS. Many of those MOUs are older or don't have strong enough language to clearly define the roles between CPS and our family advocacy programs. As the person that oversees these family advocacy programs for the installations, I definitely see a benefit in having formalized requirements come from both the Department of the Navy and also the state of Maryland for MOUs between NDW installation FAPs and local CPS. I think mutual mandates for formalized agreements will assist in bringing the family advocacy program, CPS, to the table more frequently to ensure that each party is clear on the roles, jurisdictions, procedures, and capacities that ultimately benefit the safety of military children. Thank you.
All right, those are the people set to testify. We'll hear questions from the committee now. We'll start with Delegate Nicole Williams, please.
Hi, Mr. Chairman. Thank you so much. And first, I just want to thank Delegate Valentino Smith for bringing this bill, this really super important bill. I did have a question. What happens when there is a transfer with the family by chance?
So, thank you, Delegate Williams. That's probably one of the most important reasons for this bill is what the military was saying a lot were that a local family services unit be working on these important issues and the military family be transferred. And because there was no agreement between the military base and the family services unit there, the information never followed. And so these cases could get lost or not followed up. And you hear all too many times from your testimony on your child abuse and your domestic violence bills that letting something fall through the cracks never ends well.
Gotcha.
That's why this is important.
Thank you. Thank you so much. And I have a second question, Mr. Chair. Also too, you mentioned that there are some jurisdictions that are not complying with this, but it's required under federal law. Is there any penalty? I mean, I don't understand why they're not complying and what we can do to kind of make them comply. Is there any penalty in place for their non-compliance or kind of, I mean, I know that's one of the reasons why we're bringing this bill forward, but.
So I'm gonna let Chris step in after this, but the point is that federal law requires the military installation to have the family advocacy unit. So now we're connecting to the federal law by creating a state statute that says there'll be required MOU between the local services department and the federally required family advocacy program. Chris, do you have anything to add to that?
Sure, I do. So the federal law requires the Secretary of Defense to collect this information, and that's effectuated through federal rule and then the Department of Defense Instruction 6400.1, which requires the establishment of the family advocacy program at an installation that has 500 or more persons, and then instructs the installation commander to collect that information through use of an MOU. So the legal requirement is actually on the Department of Defense. The best practice is a state statutory framework to ensure consistency, minimum standards for information sharing to allow better coordination between the local child welfare and military protective and rehabilitative services in support of our military children and families.
Okay, thank you. Thank you. And I saw that there were like 27 other states that have this statutory framework already in place. So thank you so much. I'm done, Mr. Chair. Thank you.
All right, thank you. Delegate McComas, please. You have to unmute yourself.
Yes, thank you, Mr. Chair. Just briefly, you indicated that Harford County with APG does not have a MOU at this point.
So yes, Delegate, 4 years ago when we brought this in, a lot of it was working with Harford County and the hope that one would be developed. And there still are always robust discussions that Chris may have more detailed information. But right now, there's been failure to secure the MOU. I, of course, have been in touch with DHS. All this has been sent to Lauren Graziano. I've been in touch with the Secretary's office. As you can see, they're not opposing the bill. And my impression is they're actually supportive of trying to encourage the local departments to do that, but they can't make the local departments do it. Hopefully the statute will be that kind of kick in the pants we need.
So I guess my question to you, Delegate Valentino Smith, is who's the initiator? Is it the local Department of Social Services is the initiator, or is it the Aberdeen Proving Ground military commander? Because the reason I'm asking is because I know Harford County has a great relationship with the commanders. We've had some really great commanders. So I'm kind of wondering where the disconnect is, because I'm sort of like surprised because we have a child advocacy program. So I just, do you know, or?
I have not from Lauren Graziano on the department's been given the details. We've very much talked about the issue, but not the details as to why. I don't know if Chris Arnold has any more information, and we can work with you more on that after the hearing.
Okay.
Sure. So ultimately, the APG memo of understanding with Harford County DSS was executed in November of 2017, but there are some, omissions in the language there. And while the MOU addresses reporting for child abuse and neglect cases that occur off posts, it does not allow mandatory reporting to the FAP personnel of child abuse or neglect cases involving soldiers and their families. So the provision within this bill that would, help identify by asking the question, if there is a military affiliation, would improve the framework under which that MOU operates. Cases which aren't referred to the FAP are not afforded the opportunity to receive immediate resources, treatment, and support. Non-reporting of these cases from HCDSS prevents statistical reporting of data for the Army. So passing this bill will improve the framework. I cannot speak to why that's the product that was ultimately executed, but I can say that this bill will fix the issues that it does have.
Okay. Thank you. Thank you, Mr.
Delegate Erican, then Delegate Cox.
Thank you, Mr. Chair. I also represent part of Harford County. Can we get a copy of that MOU that's already on file so we can sort of just look at it and see what might be missing and how it's going to change? That would be helpful.
Sure, thank you. And like I said, we've been coordinating with the department on this for several years.
Thank you.
All right, Delegate Cox.
Thank you, Mr. Chairman. Thank you to the panel. I just want a quick question to the military experts. This is an MOU proposed for referrals from the county agencies to the DOD. Is that the purpose of this, or is this proposed to then also allow the DOD to send cases to the county?
It is a reciprocal, information sharing environment, programmatically speaking. In terms of what we're trying to do with the MOUs, it would be identifying, when there's a military affiliation.
So a quick follow-up, Mr. Chair. In that context, is the DOD command on board with referrals to the counties so that you don't have a concern with continuity of service?
Yes, they are. And for more insight into, how an MOU works, I would refer that to, the FAP manager, Major Facet Eckhart, or the FAP supervisor, Ms. Pallett, that can explain a little bit how it works in that direction.
Okay, thank you.
I'm happy to speak to that. So all of our family advocacy program case managers are licensed social workers or licensed marriage and family therapists. And so per their licensure, they have a requirement to report any suspected child abuse to the county CPS. So that is how that is covered.
Are there further questions for the panel? Seeing none, thank you all very much. That concludes the testimony on House Bill 646. Thank you very much, Delegate Valentino Smith. We'll now go to Delegate Shoemaker and House Bill 476. Delegate
Thank you. Thank you, Mr. Chairman.
You'll get 3 minutes, Delegate Shoemaker, and then there are 5 other people to testify. Yes, 5 other people to testify, 4 in favor, 1 opposed. So we'll hear from Delegate Shoemaker, then Molly Cole, Linda Stolkovich.
Yes.
Stolkovich and Vince McAvoy. We'll hear from them first, and then we will hear the one to testify in opposition. So with that, for 3 minutes, Delegate Shoemaker.
Thank you, Mr. Chairman, members of this esteemed committee. I brought this grandparents visitation bill last year during our pandemic shortened session. And I can tell you that the circumstances that gave rise to this legislation certainly haven't changed in the last year. I mean, often it's the case that grandparents play a pivotal role in the lives of their grandchildren. I can tell you anecdotally that in my simple country law practice, I have won 2 grandparents' custody cases just in the last 4 months. And in both of those situations, the biological parents, both of them, in both cases, both biological parents were in the throes of drug addiction. So this bill, which I brought on behalf of my constituents who are in the waiting room, I guess, ready to speak, merely seeks to add some clarity to the law. And I am not going to repeat and offend the intelligence of this committee. I'm not going to repeat that which I have put in my written testimony. I would direct you all's attention to that. But, I really think that this is a case where we need to hear right from the horse's mouth, as it were. And I would like to defer, Mr. Chairman, to the Stolkoviches so that they can share their very compelling story. Thank you, Mr. Chairman.
All right, they will have 2 minutes each. We'll start with them, and then we'll go. Actually, there are only 3 people to testify in favor, Mr. McAvoy and the Stolkoviches. So we'll do, what I'm going to do is I'm going to set the clock at 4 minutes for Mr. and Mrs. Stolkovich, and they can use all the way up to the 4 minutes between the 2 of them. So
thank you, Mr. Chairman.
Whoever would like to start.
Hi, my name is Linda Stolkovich, and I want to thank you for hearing my testimony today. We lost our daughter 5 years ago, and our ex-son-in-law refuses to let us see her. We had rights when he lived in Pennsylvania, and we were able to have visitation rights. Then he moved to Maryland, and after he moved to Maryland, he took up residency within 6 months, and he would not let us see her again. So we have not seen or heard from our we haven't had any communication in 3 years. We have we did go to court last year. We finally got a court date, and we were told at that time that there was no law in Maryland, and that if we continued to take our next 4 days, because we had 4 days, if we continued to do that, that we would lose because Maryland has no law. So they told us, we were instructed by the lawyer to come up with some kind of a deal that we would kind of keep her and him kind of connected into our life. So we signed an agreement. It was a court-ordered agreement that we had 2 therapists to sign. One was for our granddaughter and one was for us and his family, so that we could kind of come up with some kind of an agreement that we would be able to see our granddaughter. Well, since then, it's been a year since we signed the agreement. He stopped taking her to the therapist. He only took her a couple times. He has gone to none of the family therapies. They have written to him. They've asked him, and he's not following the court order. He's not doing anything. We're putting money into a 529 account for her. Since last year, we've put $20,000 in the account in hopes that he would let us see our granddaughter. And there's nothing. We have gotten absolutely nothing. And when we were told that if we could get him in contempt of court because he has signed this agreement, which is for her benefit, then this child should be in therapy. She lost her mother when she was 5 years old, and her whole family on her mother's side has not had any contact with her. And we were told that because Maryland doesn't have a law, that we can't even get him in contempt of court, which is crazy. Why is the system not working for us? We have done everything. All we want is visitation rights for our granddaughter, which Maryland has nothing, and the law is protecting him. So we need help. We need help with getting something on the books that says that Maryland families, and I'm sure we're not the only family that's going through this, because a lot of grandparents, and it's proven, are very detrimental. It's a no-win for grandparents, to be involved in children's lives. And she's going to be 10 years old. I mean, we got one letter from her. She wrote us a letter in October, and she told us she missed us. So we know, that this is nothing but sabotaging our relationship. We wrote her back, and we've written her several letters since then. And here it is February, and we still haven't heard anything. So we know he's not giving her the cards or giving him what we're sending to her. So we're at a loss. We don't know what to do. And that we're told Maryland has no law. So we have nothing. So what do we do? We need help.
Have another 15 seconds or so from Mr. Solkovich if he wishes to add anything more.
Yes, I would.
Okay.
Thank you very much for giving me this opportunity. I would love to see my granddaughter. It's horrific since I lost my daughter, but it's very frustrating knowing that we can't see her. There are many other states in the union that do have grandparents' rights. Some easy to get into, some not so easy to get into. Grandparents should have rights. Grandchildren are an integral part of a family. And there are many, many kids in Maryland that would do a heck of a lot better if they could be part of a family, grandparents included. And it's just, I can't understand it. This guy he's detrimental. Both therapists have said they would come to court with us and testify that he is doing more harm than any good for the child. I hope you guys can find it in some way to add some meat to these laws where we can start seeing our granddaughter as well as other grandparents throughout the state of Maryland. Thank you, sir.
Thank you very much, sir. All right. We will, the third person who's here to testify is actually testifying favorable with amendments. So we'll take him next. We'll take questions first to the delegate and to Mr. and Ms. Stolkovich. So are there questions to the delegate or to the Stolkoviches? Seeing none. All right. Seeing none. So I thank you all very much for speaking with us today. We'll go now.
Thank you, Mr. Chairman.
You bet. We'll go now for 2 minutes, favorable with amendment to Vince McAvoy. Mr. McAvoy, you're muted.
There we go. So
Go ahead, 2 minutes.
All right, thank you. Thank you, committee, and thank you, Delegate Shoemaker, for bringing the bill. My stance on this has evolved over the years because, of course, you know that I'm constantly fighting for fathers to remain in the lives of their children. I've spoken to many grandparents outside that hearing room who had expressed this concern, and I assured them they should also be seeking to make sure that their sons have access. That said, I want to point out that I think this is a good bill. I think that it's integral that we have custody added as an amendment, that this is strictly relating to visitation. And I bring that up because we have an issue where in Baltimore I've seen men come to the office where they are trying to get access and they can't get access because no one told them while they were in lockup that there were custody issues going on. But aside from that, I think it's really important to have grandparents involved, and the children, they don't know these children that are young. Their brain processes this as the death of their grandparents because they don't see them. And we mustn't allow that to happen, particularly when we have so many grandparents who are trying to stay in the lives of their children and affirm their heritage and share with them and to help raise them and guide them. So I think that Delegate Shoemaker's bill is vitally important, and I hope that you all vote favorably on it. Thank you for your time.
Thank you. Are there questions for Mr. McAvoy? Seeing none, we'll go to the opposition. Just one, Lorraine Preet or Pretty. Is there anyone else, staff, is there anyone else in the waiting room? Yep, there she is. All right. Yep. So when we get them ready, let me stop the train here for a second. Is Delegate Cardin, do you have a question for Mr. McAvoy?
Oh, I'm sorry. It's actually for the sponsor, but I can.
Well, let's do that now. Let's go ahead and ask your question of Delegate Shoemaker, and then we'll go to the next witness.
Thank you. Delegate Shoemaker, thank you again for bringing this bill. I do remember from last year, and I will recall, and I have had the opportunity over the last few months to be able to observe you in practice.
I apologize.
When we were both in the courtroom at the same time, and you are anything but a small town lawyer, I will say that.
Thank you, sir.
I'm just wondering, did you have any opposition come to you? Anybody who made any during in the interim while we've had time, anybody came to you and said there's going to be some unintended consequences of this in some way, shape, or form?
No, sir. No such feedback.
Okay. Thank you.
All right. Further questions for the sponsor? Seeing none. Thank you very much, Delegate Shoemaker. Now we're going to go to the witness signed up to testify in opposition. And it's Lorraine, and I have mispronounced your name, I'm afraid, but is it Pritt? Okay, well, you are muted. You can take yourself, put your microphone on, and we'll hear from you for 2 minutes.
Thank you. It's Preet, Lorraine Preet. Thank you, Mr. Chairman and members of the Judiciary Committee. I am Lorraine Preet. I am a member of the Maryland State Bar Association, and I am testifying for the Family and Juvenile Law Section Council. Our legislative committee had reviewed this law and determined that it doesn't really change what's already in 9-102 for grandparent visitation. Because it provides that both of the child's living parents consent to visitation. They can certainly do that without a law, and one of the child's living parents can consent. That also is applicable now without a new statute, and that both of the child's living parents are unable to consent. That also would be allowed as currently as the law is. It still provides for exceptional circumstances and the best interest of the children. So it's our position, we're opposed to this because it doesn't alter the rights of a grandparent by the provisions of this bill.
Right. There are questions. Very briefly, committee, I have a bill in economic matters that I'm going to need to go and do. So with this, I'm going to hand it over to the vice chair and she will take questions from the committee for the witness. So I'm going to step back. Thank you to the vice chair.
So we'll go with Delegate Cardin and then Delegate McComas. Delegate Cardin?
Thank you, Madam Vice Chair. Thank you, Ms. Preet, for testifying. You understand the issue, though, that has been raised by this family and these concerns. If this legislation doesn't solve the problem, what could?
It's a good question. I think you would find differences on the Family and Juvenile Law Section Council as well, because I certainly sympathize with grandparents, particularly grandparents who have been very invested in their grandchildren's lives. But I just don't think it's our position as the Section Council that this law doesn't do it.
Okay, so I'm just going to say this, regardless of whether this bill passes or not, perhaps in the future, you knew this legislation was coming because it was here last year. It might have been helpful that the bar might want to come and try and figure out how to solve these problems for this section of the bar with the legislators, so that, you know, because if it doesn't solve the problem, then I understand your perspective. But we have these grandparents who are trying to do what is in the best interest of the child, and they're not allowed to. So we just need somebody, kind of like the experts, to come and help us figure out how to solve the problem.
Certainly, I don't disagree.
Delegate McComas?
Thank you, Madam Chair. Just a couple questions. You know, the only person that isn't in this calculus is the child. And I had the wonderful opportunity to know my grandparents. And I learned a lot of good things, and y'all might say I learned a lot of bad things, but the bottom line is where is the child in this equation? That concerns me greatly. And the other thing is that, you know, okay, so we can't come to an agreement. What do other states do? Do we have to have a study on this issue so we have a meeting of the minds? Because as time goes on, the kids are losing, and sometimes in many families, extended family are really, really helpful, and not just the grandparents, but the aunts and uncles. And what can we do? Where's the Section Council on this? Why aren't we trying to expand the people that can be important to these children's lives?
And I don't want to speak to my beliefs on that, because it may differ from other people in the Section Council, but I'm thinking we did a study on joint legal custody and physical custody. And I agree that if we could look into grandparent access when it's been done in, I believe the Skolkoviches said 27 other states. So I too had a very good relationship with my grandparents, and my whole life would have been completely different, I think, without that opportunity. But I think maybe there should be more done before a bill like this is brought.
Are there any other questions for this witness? Okay, seeing none, thank you, Delegate Shoemaker. And that concludes the testimony on House Bill 476.
Thank you very much.
Delegate Shoemaker, just if you're ever in our committee again on Thursdays, we're doing animal prints.
Oh, I did not get the memo on that.
So you can get a nice tie like Delegate Griffith, a little pocket square.
I may have something in a drawer somewhere.
This is our first day, so.
Okay. Thank you very much.
Good to see you.
Good to see you.
Next, we are going to have House Bill 449, Delegate Bartlett. And while you are getting ready, there's quite a few witnesses. So first, I will call Delegate Bartlett, Scott Poyer, Mr. El Amin.
Actually, Madam Chair.
That's not right.
Yep.
We have a
That's not
short
right.
list for this one.
Yeah, so Delegate Bartlett, Jenny Egan.
No, we have a short list for 449. We only have 3 witnesses, I believe.
Oh, I'm confused. You have 2 bills.
Yes.
The 2. Okay, sorry. So it's Scott Poyer, Mr. El Amin, and then there's 1 unfavorable. So I'll let you go ahead. And Miss El Amin, and I see them both here. Okay, so I'll let you go ahead, Delegate Bartlett.
Thank you, Madam Vice Chair. My name is Sandy Bartlett for the record, and I am from Anne Arundel County. And with me today, I have my clerk of the circuit court from Anne Arundel County, who will also provide testimony as in support of this bill. What does this bill do? We always ask that question. Well, it's very simple. It substitutes in a marriage license the words husband and wife to party 1 and party 2. It allows for electronic record keeping by the clerk of the court. As I mentioned, we will have the 2 clerks of the court, Montgomery, Anne Arundel County and Prince George's County are here today as they process marriage licenses, and they can speak to the bill. Thank you for taking the time to listen to them, and I appreciate a favorable vote. Thank you.
Madam Chair, I think you're muted.
Yeah, I am. I was on microphone Teams this morning. Sorry, I'm like, Mr. Poyer.
Thank you, Madam Vice Chair, and thank you, members of the committee, for this opportunity to testify in support of HB 449. For the record, my name is Scott Poyer, and I am the clerk of the circuit court for Anne Arundel County. My testimony today is on behalf of the Maryland Circuit Court Clerks Association, which represents the elected clerks of the circuit court in Maryland. Our Clerks Association supports HB 449 because it updates 2 sections of the family law article related to marriage licenses and records. Specifically with regard to the first update, Family Law Section 2-403, Forms of Licenses, currently requires the applicant for a marriage license to list the name of the husband and the wife on the application form. In order to bring this section into conformance with the state of Maryland's Civil Marriage Protection Act of 2012, which allowed same-sex marriages, HB 449 proposes to change the words husband and wife to party 1 and party 2. In essence, it's an update that brings this law into conformance with the law that passed in 2012. My colleague will discuss the second update in more detail. Our association hopes that you will look favorably on both updates to the family law article. And thank you, Delegate Bartlett, for your sponsorship of this important bill. Thank you for the opportunity to comment.
Thank you, Mr. Poyer. Good to see you again. And Ms. El Amin.
Good afternoon, and thank you, Madam Vice Chair and members of the committee for this opportunity to testify to support of HB 449. For the record, my name is Mahasan El Amin, Clerk of the Circuit Court for Prince George's County. My testimony today is on behalf of the Maryland Circuit Court Clerks Association, as my colleague has already stated, who represent the elected clerks of the Circuit Court for Maryland. As my colleague mentioned, our Clerks Association supports HB 449 because it updates 2 sections of the family law article related to marriage license and records. Specifically, regarding the second update, Family Law Section 2-501, Marriage License Book, currently requires that each clerk keep a marriage license book. While officially marriage license records were kept in paper book format for many years, the transition to electronic records occurred many years ago. HB 449 updates that statute's wording to accommodate modern technology by proposing to allow the records to be kept in a marriage record book or an electronic record. Our association hopes you will vote favorably on both of the updates to the family law article. Thank you, Delegate Bartlett, for sponsoring this bill, and we look forward to the opportunity, and thank you for the opportunity for us to comment on this bill.
Thank you. I see 1 question so far, Delegate Fisher.
Thank you, Madam Chair. And I had to ask a question to my favorite clerk, my clerk. It's so good to see you, Madam Clerk. I just had a question about and I have never been married, so I just don't know. Do people still have to bring like any blood paperwork or anything else when they get the license? And is that the only part, the husband and wife, that has a gender distinguishing factor in the process?
Yeah, well, you do, yes. So in terms of paperwork, I mean, they have to bring an application. They bring the application, they have to appear, and they basically affirm, just take a small oath, basically saying that they are who they say they are, and that they're over 18. In terms of the distinguishing of the gender, Mr. Boyer and I have both looked, and it seems like this is the only form that we're waiting to change.
Thank you so much.
Nice to see you too.
Good to see you.
I see Delegate Cox.
Thank you, Madam Vice Chair, and Delegate Bartlett. Good to see you both. And I just had a question for the clerks. There are two things, as I understand, that you're doing. Both of them are a very large historic change to the historical records. One, the one would be to change it to the Party 1, Party 2, and then the second change would be to eliminate the written book. Is that really the posture of the bill that's doing those two things, just to clarify?
Delegate Cox, I'll answer first and then see if Clerk Amin has anything else to add in. It's really just a cleanup. The other records, as Clerk Amin had mentioned, other records controlled by the judiciary have been updated long ago with regards to Party 1, Party 2. And then as far as the update of electronic records, we're just catching the statute up to current practice. We've been maintaining electronic records for quite some time now. So we see this more as a cleanup type of effort.
If I could follow up, I mean, I don't have a problem with electronic records, obviously, but my concern about that issue particularly is that, as we all know, there are repeated hacks that go on, and particularly the federal government has suffered some severe losses of information. So the nice thing about having a written book backup is you have historical records in writing as well as the electronic record. I think that's a smart and appropriate thing to consider for posterity when you're doing research, for instance, on family trees or on property records, et cetera. It's nice to make sure you've got hopefully backup if it's 100 years from now. And then the same thing would apply in my concern with the elimination of husband and wife. I mean, that's a massive historical change. Adding the option of Party 1, Party 2, if somebody were to opt in, seems like a more reasonable approach rather than to actually eliminate a historical practice. Wouldn't you be able to just simply add in or allow to opt in to Party 1, Party 2?
So with regard to the electronic records, they are triple backed up. The judiciary's IT maintains not only the active server that has the information, they also have a backup of that, and then they have a backup of that. So the electronic records are very well maintained in the event that there's a hack or anything like that would take them down. So in my opinion, the electronic records do provide appropriate levels of backup, because that's a very good point. You need to have electronic backup, especially in this day and age. You want to make sure you do not lose any data, and the judiciary makes sure that we do not lose any data. We're also keeping all the court records electronically too, and all the court records are backed up with the equal amounts of care to make sure that we do not lose any of the records. With regard to the Party 1, Party 2, it would, right now it's just a cleanup. The other forms that Maryland are using already say Party 1, Party 2. That way it doesn't discriminate with regard to husband and wife. You can use either. So it's just meant to be neutral, is what I would say.
If I could just real quick follow up on that. I mean, my concern is that it actually does discriminate against those who wish in their marriage records for posterity, to be listed as husband and wife. I mean, it's a huge change. I just wanted to clarify that. I think it'd be better. I don't have a problem with having an opt-in to Party 1, Party 2, particularly in the area of marriage. But thanks so much. Thank you, Madam Chair.
So we have 4 more questions. We're going to go Delegate McComas, and then Delegate Arakan, and then Cardin, and then Bartlett. So Delegate McComas.
Thank you, Madam Chair. Just briefly, names change so that a woman's name, like Trent, I'm going to use Trent. Trent could be a male or a female name. It's hard to say. Now, I know that one of the delegates is a female and she has the name Trent. I think that by Party 1 and Party 2, if and this is kind of going off of what Delegate Cox said, let's say 100 years from now, society changes. Some names are more popular than others. And as the society changes, it may be very difficult to know if the parties were, male, female, or female, female, male, male. And so folks doing research might be very interested in that. And so you're taking away that ability. So I do think the opt is a good idea. And the other question that I wanted to ask you, and you can respond to that if you want, is when you come in to get a marriage license, is there any requirement for identification like a driver's license or a birth certificate or something that indicates what your age is?
I'm sorry. Am I at the mute? I'm sorry. You do have to present some form of ID. Yes.
And ma'am, is it picture ID?
A picture, a photo ID. And right now, right now, because we are in COVID, we're actually getting our applications via mail. So I know my office requires a photo ID just to verify.
But if we didn't have COVID and you just come in, you still have to have a photo ID.
Yes.
Okay. And then does it have your birth date on that photo ID?
Yes.
Okay. And basically, have your offices had training in fake IDs like the alcohol board have, that, these kids can't come in and get married at the age of 12 or whatever?
I see my colleague shaking his head. I know that my staff is very diligent with looking at all records that are presented and questioning authenticity.
We do. I agree with Clerk Ellerman, and we also make them sign an affidavit. So they're a penalty of perjury if they are lying about it. So.
Now I got just one other quick question, and I apologize, Madam Chair, but we've all very concerned about identity fraud and identity theft. Is there any record within your paperwork that has after you decide, hey, they're legitimate, they've shown you their ID, that there's no like social security number anywhere in the records the public would see, or any dates of birth, or anything that somebody could, garner some information and then, cause some problems for people?
I'm shaking my head. No, I'm sorry. No.
Okay. Thank you. Thank you both. Thank you very much.
Thank you, Delegate.
Hey, Delegate Arakan.
Thank you, Madam Chair. I have two quick questions. So currently right now, if 2 women are showing up to get married, someone has to pick the husband line? Is that what's happening?
What we're doing is we just cross it out and we put in the wife and wife.
Yeah, okay, that seems kind of silly, but yeah, thank you for bringing this bill forward. And secondly, for the association, could you tell me what the breakdown was in the vote? Was it unanimous?
Yes, we consider this a very cleanup bill, just to correspond with what we're doing in today's
with the bills that have already passed long before. Yeah,
exactly.
Okay, thank you very much.
Hey, Delegate Cardin, and then Delegate.
Thanks, Madam Chair. I just real quick. So I had a constituent who came to me with an issue that they were dealing with, and I don't remember exactly what it was, but it was a family matter. It was a property matter, and they had to prove that they were married, and they couldn't find a copy of their marriage license. So they went to the clerk's office, and apparently there was a flood, and they couldn't generate a copy of it for them. Would this solve that problem?
Yes.
Yes, we believe it would, because in the old days when they kept paper records, things happened to paper records.
Yes.
We archive them, but there are fires, there are floods. The
And-
electronic with triple backup, we make sure that it's archived.
But
That's
then
exactly what-
one more quick question. So then if there's like ransomware and somebody destroys all your electronic information, are you going to have paper backups? I'm sorry, maybe you said that and I just missed it.
We would be able, we do have electronic backup of the data. So if we lost the active server, the data could be reconstituted with the backup information.
Wonderful. Thank
Yeah,
you.
And this would be no different than what the Maryland Judiciary is doing with our Maryland MDAC, where we're converting all of our cases to online case management.
Thank you.
And last question is Delegate Bartlett.
Well, thank you, Madam Chair. I am happy to say that Delegate Arakan actually asked the questions that I was going to ask. So no further questions.
Okay, that concludes the testimony and the hearing on that bill. And now we will move on to Delegate Bartlett's next bill, our final bill, House Bill 315. Hold on one moment. Sorry, there is one favorable with an amendment for 449. And I believe that is Mr. McAvoy. He's coming in now. I didn't see him. I thought he wasn't connected. I apologize. He is, Mr. McAvoy is here with an unfavorable. So we're still on 449. Mr. McAvoy, you have 2 minutes.
All right, thank you so much, committee. I've been, paying attention to what John Morrissey's doing with the, with MDEC and so forth. As an IT person, I can appreciate that. I don't see this as a cleanup bill. I see it as a mislabeled bill. By my math, the vast majority of Maryland residents will be husband and wife. By my calculation, 99.8%. So what that means is that really on any form where we have something like that, that's what we have other for. And the present practice of scratching out or writing over the other names, I think is more appropriate given the vast amount of people who qualify as husband and wife, and let's not minimize that. I ask and urge an unfavorable on this, or for at least that part to be crossed off. And so, thank you so much for your time, committee.
Are there any questions for Mr. McAvoy? Okay, seeing none, thank you. Now that concludes the testimony on House Bill 449. And we will move forward with House Bill 315. And we will call Delegate Bartlett, State's Attorney Mosby, Michael Joseph, Laura Nereeder, I pronounced that wrong, I'm sure, and Stephen Dreisen. So let's just give everybody a minute to come in. State's Attorney Mosby. If you're coming in, please mute yourself. Thank you. Okay, Delegate Bartlett, you want to go ahead? And this again will be 3 minutes for Delegate Bartlett and 2 minutes for all those testifying. Go ahead, Delegate Bartlett.
Thank you, Madam Chair. To the members of the House Judiciary Committee, House Bill 315, the Juvenile Interrogation Protection Act, is proposed legislation to codify that which is already the law of the land. One of our inherent rights as brought by the Fifth Amendment, and I quote, "No person shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law," close quote. House Bill 315 is proposed legislation that codifies the rights of children when they are in custodial interrogation. Children are afforded these protections of the Constitution, and the Supreme Court has issued opinions regarding the application and interpretation of these constitutional protections, including when and how they apply, especially in circumstances that involve children. In JDB versus North Carolina 2011 case, the court discussed whether the age of a child is relevant to the custody analysis of Miranda warnings and gave a two-pronged objective test. Law enforcement knows the circumstances in which Miranda warnings apply. The court decided Miranda back in 1966, that's 55 years ago. House Bill 315 does not change Miranda warnings and how they apply, does not change when Miranda warnings apply. Law enforcement has the inherent duty to protect the interests of children and therefore must follow the US Constitution and the US Supreme Court's interpretation on the applications of those rights. Maryland is far behind. 33 states have already implemented a version of the proposed language in House Bill 315. In fact, 19 of the 33 states have seen no change in the trends for arrests, thus appearing not to hinder law enforcement's ability to execute arrests. Since 1999, Maine requires parental consent in juvenile custodial interrogations. North Carolina makes any confession not made in the presence of the child's parent or legal guardian inadmissible in court. New Jersey provides a child with the right to counsel throughout the interrogation process, and this right cannot be waived without consulting legal counsel or parents. House Bill 315 does three things. One, it requires notification of a parent or guardian when a child is in custodial interrogation. Two, counsel be made available to the child in custodial interrogation. And three, appropriate language of Miranda warnings in which a child may understand. Please vote favorable for House Bill 315 so that Maryland can meet its burden to our children. Thank you.
Thank you, Delegate Bartlett. Next, State's Attorney Mosby.
Good afternoon, Madam Vice Chair, Mr. Chair, and distinguished members of the committee. I'm here before you today to testify on support of House Bill 315, Juvenile Interrogation Protection Act, which is a vital piece of legislation that seeks to not only follow the science in recognizing that children under the age of 18 are fundamentally and cognitively different from adults, but serves to protect those of our children that come into contact with the criminal justice system. In the past 6 years as the state's attorney for Baltimore City, the need for this reform has become crystal clear to me after the work that my office has done through our Conviction Integrity Unit, where 8 out of the past 10 exonerations, innocent individuals that were wrongly accused, convicted, and incarcerated for cumulatively 270 years, involved the faulty testimony of juvenile witnesses. The best illustration of this miscarriage of justice occurred last year when Alfred Chestnut, Ransom Watkins, and Andrew Stewart were freed following an investigation in my Conviction Integrity Unit after spending 36 years in prison for a crime they did not commit. It was on the eve of Thanksgiving in 1983 when these 3 16-year-old teenagers were pulled from their beds at midnight and accused of murdering 14-year-old Duckett. These young men were subsequently convicted and condemned to spend the rest of their lives in prison based on the now recanted testimony of 4 juvenile witnesses who were a mere 13, 14, 15, and 16 years old at the time. These juveniles witnesses were repeatedly pulled from school and interrogated by the police for hours without the knowledge, consent, and/or presence of their parents or legal counsel, and were subsequently coached and coerced by the prosecutor and police into identifying 3 innocent boys that were sentenced to life upon their false testimony. You may be wondering how this happens. Science has proven that children's brains are still developing, particularly in those regions responsible for logical decision-making. It's proven that they're not only unable to fully understand the implications of waiving their Miranda rights, which include the right to remain silent, but as children, they're uniquely susceptible to psychological pressure, where they don't always appreciate the long-term consequences of false statements and are more likely to fear authority figures. With clear evidence that children are unable to protect themselves against these pressures, it's up to our legal system to establish safeguards to prevent coercive tactics from being used to ensure that young children are not interrogated without the presence of their parents and their attorney. That's what this bill does. And while Alfred Chestnut, Ransom Watkins, and Andrew Stewart will never get back the decades that they've lost to incarceration, perhaps their torment, misfortune, and anguish will shed light on the need for reform around this very important issue. For these reasons, I ask that you vote favorably on House Bill 315.
Thank you, State's Attorney Mosby. And next, Michael Joseph. I see you there. You just need to unmute yourself, Mr. Joseph. Oh, okay.
My name is Michael Joseph. I'm an attorney in New York City, and I am here to advocate for the passage of the bills before the Maryland legislature. It is absolutely essential that juveniles, children, have presence of attorneys and parents if they are to waive their Miranda warnings. It has been argued that the Constitution is being followed under the law now, but it is not, because the meaning of Miranda is that prior to interrogation, an individual must understand and waive his or her rights. We know that juveniles don't have the maturity and experience to do so. If your 14-year-old or 15-year-old came home and said, I thought about it, I'm dropping out of school, you wouldn't accept it. They can't join the armed forces. They cannot sign a contract. Why is that? It's because it's well recognized that they don't have the ability and judgment to make those decisions. I was involved in what is known as the Central Park jogger case in 1990 in New York, where 5 juveniles were convicted based upon false confessions. You may have seen Ava DuVernay's Netflix series, When They See Us. If you haven't seen it, you should watch it. That case turned around some 12 years after their conviction, when the district attorney of New York County moved to vacate the convictions because an individual had not been charged, confessed to the crime, and after an investigation, his DNA matched, which none of the 5 juveniles did. This would not have happened if an attorney had been present. And finally, parents being present are not sufficient. When we are dealing with issues with our children, it is most difficult. We are affected in the same way or even more than parents. My client, Antron McCrae, in the Central Park jogger case, police had his father talk to him alone. The father threw a chair at him and said to his 15-year-old son, you better tell the police what they want to hear. That's the only way you're getting out of here. Had an attorney been present, that would have never occurred. And I urge you to pass this legislation. One final thing, people say, well, it may interfere with investigations. It's a fundamental right. And one could say the same thing about the Fourth Amendment. Why do we need to get search warrants before we search a home? Or why do we need to get wiretap warrants before we listen to communications? The reason is because that's fundamental to our constitutional protections. And I urge you to pass the bill so that juveniles are protected. Thank you.
Thank you. And I see Mr. Chair is back. So next we are going to call Laura. I'm not going to try to pronounce your last name. I apologize, but go next.
Good afternoon. I'm Laura Nyrider, co-director of the Center on Convictions at Northwestern University, where my expertise is in juvenile confessions. Around the country, police use the same standardized set of psychological techniques to interrogate suspects. These techniques work by making a suspect think he's trapped and that confessing is the only thing that will improve his legal situation, even though in most cases it won't. These These psychological techniques are used on adults and kids alike, and that's a problem. Children under 18 aren't equipped to make the high stakes decisions that someone being interrogated has to make. That's why research shows that children are between 2 and 3 times more likely than adults to confess to crimes they did not commit. The problem of false confessions is one that Maryland children have lived. Cecil County resident Alan Chesnut was 16 years old when his neighbor was stabbed to death. With almost no leads to go on, police brought Alan in for interrogation without a lawyer. During the interrogation, police accused Alan of murder and falsely told him his DNA was found at the crime scene. Eventually, Alan agreed to say that he had killed his neighbor. Later, he explained, "In my head, I thought if I told them stuff, they would let me go." Instead, Alan spent months in jail before DNA from the crime scene identified the actual perpetrator and prompted Alan's exoneration. While Alan was in jail, he reports having been stabbed twice. His mother described his ordeal as pure hell. Maryland has a long history of adopting laws that are meant to protect kids like Alan from the dangers of unguided decision-making. If you're under 21 in Maryland, you can't buy cigarettes or possess a handgun. If you're under 18, you can't get a driver's license, sign contracts, or even use tanning beds. It's time to extend that thinking to the interrogation room. We need to protect children from undergoing interrogation without a lawyer. This bill is a necessary step to protect against false confessions. Thank you.
All right, I think we're next going to Stephen Dreisen, please, for 2 minutes.
Good morning, good afternoon. My name is Stephen Dreisen. I'm a law professor at Northwestern University. I co-direct the Center on Wrongful Convictions with Laura Nyrider, who is my former student. And Laura and I, and at the center, we have exonerated more than 40 men and women, more than half of whom falsely confessed, and a good percentage of them were only children at the time that they confessed. Before any custodial interrogation, children must be advised of their constitutional rights to silence and to counsel. And only after a child gives up those rights and agrees to talk with the police can interrogation proceed. This has been the law in this country since Miranda versus Arizona. And ever since Miranda, the law has failed to protect children. For over 50 years, and in many of our confession cases, we have seen how police officers have become experts at neutralizing Miranda rights. They read the rights to kids in rapid fire fashion without asking kids to explain them back in their own words. They minimize the importance of these rights. And they suggest to kids that only the guilty would hide behind a lawyer. And as that video clip shows, they tell suspects, you don't need a lawyer because you are a juvenile. It's just too easy for police to get children to give up their rights, whether they're witnesses or suspects. To many children, the Miranda rights are like a foreign language. They're words without meaning. Many don't understand the meaning of the words, and even fewer know what their function is. They don't know what attorneys do or whether asking for an attorney would help them or hurt them. And even if they do understand the Miranda rights, many are pressured by police to give them up involuntarily. The situation is clear. Kids can't be relied on to invoke their right to counsel and protect themselves against the risk of coerced or false confessions. That's why the International Association of Police, Chiefs of Police, has recommended that kids under 18 consult with attorneys before interrogation. That's also why Illinois and California have recently adopted laws requiring attorneys for children before they are questioned by police. It's time for Maryland to follow suit. It's time to protect our children. It's time to make Miranda work for them. It's time to give children the same rights that we have given to police officers for years under the law. Officers
wrap up, that would be great.
The right to counsel before they are interrogated. Support House Bill 315.
Thank you very much. Jenny Egan.
Thank you, Chair, and thank you, members of the committee. My name is Jenny Egan. I'm a juvenile public defender in Baltimore City. I have interviewed and represented thousands of children, and only a small fraction of my clients have ever been able to explain to me in their own words what Miranda meant. Children often tell their public defenders that they believed that waiving their rights meant waiving. I had one client tell me when the police told him he had a right to an attorney, he believed that he had to write me a letter and that he would be held in a cell until I responded to him via post. You will hear today extensively from experts that research has established young people are developmentally less capable of understanding and exercising their Miranda rights. All children are more vulnerable than compared to adults, but children in the juvenile justice system are uniquely vulnerable. Between 65 and 75% of youth in the juvenile justice system have cognitive deficits, and 2/3 of them have a diagnosed mental health disorder. 72% of children arrested in Maryland are Black or Hispanic. Recent research found that Black youth are more likely to be wrongfully convicted as a result of false confessions than any other race. This is necessary. The Constitution guarantees children the right to remain silent. This is already the law in California for children under 16, and the legislature just extended that protection to age 18. The prosecutor in San Francisco said that from his experience, these protections have not in any way harnessed his office's ability to prosecute crimes. We know that our opposition will argue the existing law is good enough, that the floor is set by Miranda and we shouldn't go any higher for anyone, not even kids. The underlying logic for such an argument is that if children understand their rights, they'll be less likely to waive them, resulting in fewer convictions and confessions. If children can waive their rights without ever understanding them, then those rights are rendered meaningless. It is time to make the rights guaranteed to our children by the US Constitution real and concrete rather than abstract. I ask you to vote favorably on HB 315.
Thank you very much. Are there questions for this, the first panel? Or for the sponsor? Delegate Juanita Fisher, and then you need to use the raise hand function on the Zoom, please. Delegate Cox and Delegate Williams, but thank you both very much. Delegate Juanita Fisher.
Sorry, Mr. Chair, I'm working on it. This is for, thank you, Delegate Bartlett, for bringing this important legislation. I don't know if this question is for you or you want to have one of your panelists answer. For children that either are in our foster care system, for children specifically, you know, in my district that are unaccompanied minors that are here from maybe, you know, another country, things like that. How will this bill ensure those children that have not maybe not traditional home life structure and things like that have the appropriate notice to a guardian or somebody in their life that would be there to help them navigate, you know, being questioned and things like that. So thank you.
That's a great question. Thank you, Delegate Fisher. Mr. Chair, may I ask one of my panelists? So Jenny, yes, Jenny Egan, if you could.
Happily. So thank you so much for that great question, Delegate Fisher. So that's why this bill does two separate things. It requires guardian notification and attorney consultation, because we know that guardian notification is not enough, because not all kids have a guardian, and guardians can be victims in cases. They can have opposite interests, and not every kid has a parent, as you point out. So this allows for guardian notification. So if a child is DSS committed, then the Department of Social Services and their case manager would be the appropriate contact. I will say 2/3 of kids in the juvenile justice system have had prior contact with the Child Protective Services. So that is an important question. But guardian notification, all children are supposed to have a legal guardian, and if they don't, that notification would go to the Department of Social Services, because that would become an unaccompanied minor.
Then, Mr. Chair, am I allowed to follow up or not? Okay, thanks. And we have some great legislation by some other delegates about emancipation and things like that. So what happens if somebody is under 18 but they're emancipated with this bill?
So yeah, go.
Can I?
Jenny, if you don't mind, or
can I just jump in real quick? It's my bill, and that's a great question, Delegate Fisher. I'm trying to find you on my screen. So the legislation that I proposed says that in terms of the criminal laws, you're still treated as a juvenile. So
thank you, Madam Vice Chair.
Yeah, you're welcome.
All right, we'll go to Delegate Cox then.
Thank you, Mr. Chairman. And Delegate Bartlett, I just want to commend you for the focus of this legislation. I am I can't tell you how much I appreciate the focus on ensuring that the child has a right to their parents. I love the sections about the actual notice to the parents and the right for the parents to help obtain child counsel. I had a case once where tried to get the parent filed a motion to be able to hire an attorney for their child, and the judge in the motion there was a 14th Amendment argument made, and the judge, I'll never forget, the judge said, well, what does the Constitution have to do with this? And I was okay with that because I knew I'd win on appeal, and I did. But that aside, I did see the state's attorneys were a little bit concerned about some of the issues. It looks like there's an exception for imminent life issues, threat to life, so that the children and others can be protected by the police. And then there also is a question I had, maybe we can tweak this, as to child abuse and neglect situations, particularly sexual abuse situations or other abuse situations, to make sure that the children are protected in that environment. Particularly also, how would this play out if the parent and the child want to go ahead and talk to the police, but there's this mandate that you can't waive the attorney requirement. Would that supersede the parental right and the child's decision at that point to cooperate with police?
Well, I'm going to let one of our experts, either Jenny or I think Jenny, if you want to take that, or any of the panelists want to take it, because they're actually practicing in this area of criminal defense.
Yeah, Stephen or Laura can address it as well. So the bill does two things. It notifies parents, but parents can't waive a child's Miranda rights. They can't say he doesn't need a lawyer. Only a child can do that, right? Like only the suspect can do that. So this notifies parents and guardians and guarantees that the child can consult with an attorney so that they can make that decision. Often those interests align. Usually a child, as a juvenile defender, usually a child wants me to share that information and consult with their parent, and everybody makes that decision together, but that's not always the case. And that's why it's so critical that there is parent notification and a right to have an attorney, because those are two separate parts of the bill, and those are two separate interests that must be represented.
Can I
I don't know if that fully answered your question, Delegate Cox, but I'm happy to expound further.
Well, it's just a little bit confusing as to the parent-child relationship. I mean, you said that only the child can waive it, but I think in the context of a parent-child relationship, it looks like the bill mandates a third party, an attorney, to be present to do the waiver, and I don't know that that's necessarily the.
Yes, so it requires parents to be notified and for a child to speak to an attorney before they can waive. Those are the two distinct parts. Parents are notified, which is not required under Maryland law right now. Police are not required to call a parent or tell anyone when a child is taken into custody or when they're going to be interrogated. So parents get told where their child is and that they're about to be interrogated. But that child cannot waive that right until they speak to a lawyer.
So I would support the bill, except that I think it needs to be tweaked, because the 14th Amendment, I don't think allows for a prevention of that parent-child decision in the context of a waiver. In other words, if the child consults with a parent, the 14th Amendment makes that. I mean, I absolutely agree with the bill. Otherwise, it's just to interfere with a decision to cooperate with authorities under the 14th Amendment seems to go a little too far. So that would be my only concern. But thanks so much.
Yeah, so this is a thing that's come up in the law a lot. As a juvenile defender, I have to explain to parents all the time, I represent the kid and not the parent. So the children have rights, and this is well established in case law, separate and apart from their parents. A parent cannot plead guilty for a child, cannot instruct a child to plead guilty. And what you lay out is exactly what Mr. Joseph explained happened for his client, that they brought in a parent who threw a chair at him and told him to tell the police what they wanted to hear. And that is why the consultation, I would ask Laura can address that, or Stephen too.
Yeah, Delegate, what I would add is simply that I would not think of this as interference, and I speak as a mom myself. I would not think of this as interference in the parent-child relationship, but rather as support for that relationship. I cannot tell you how many interrogation videos I have watched as somebody who practices with a heavy emphasis in this area. How many interrogation videos I have watched where a parent is either marginalized, kept out of the interrogation room. The police officers will say, let us talk to your son or daughter. They may not want to, fess up in front of you, right? Or if the parent is admitted to the interrogation room, the parent is then subjected to the same interrogation tactics that I discussed, right? Which can include legally lies about the evidence and promises that leniency will flow from a confession. Those same tactics operate to convince a parent that confessing is in the child's best interest, even though it may not be. So you see our parents that are co-opted, turned against their own kids, pressure their own kids to cooperate, thinking it's in their best interest, when in fact, they don't understand the legal ramifications. They too need this opportunity to educate themselves as a family by consulting with a lawyer.
Michael Joseph, if I may, I would just want to add that many families of juveniles who are arrested have never worked with an attorney, don't know how to contact an attorney. It's really a socioeconomic situation where certain parts of our community do not have contact with attorneys. Number one. Number two, in the Central Park jogger case, they went so far as they couldn't get a confession with the father and the mother in the room. They told the mother to leave the room and then told the father, if you want your son to get out of jail, you better get him to say what we want him to say. And I think we all know, any of us who have children, that when you're under pressure with your child, it is very difficult to have the kind of judgment that you normally would.
Can I speak to that very quickly? Delegate Cox, you started with an example of a child abuse type situation or child neglect. And that's the perfect example for why you need attorneys in addition to parents. Because many times a child is being abused or neglected by another parent in the home, and their interests conflict with the parents who are staying with the abuser or are abusing the child themselves. So it's in those circumstances where the parent's interests conflict with the child's, and the parent is really not equipped to make a decision in the child's best interest. Police officers are also trained to marginalize parents when they are allowed in the interrogation room. Sit over there, stay quiet, don't interrupt, urge your kids to cooperate. Over and over again, I have seen that, and it's part of police training manuals, not to let the parent interfere with the questioning of the child.
All right, Delegate Nicole Williams. Oh, I'm sorry, you're done? Okay, Delegate Nicole Williams.
Thank you, Mr. Chair. Just kind of also going back, since we're talking about constitutional matters, I noticed in some of the letters from some of the opposition, and I'm sure they'll probably comment later on when it's their time to speak, mentioned a concern with regards to this bill going above and beyond what is required constitutionally, exceeding the scope of practice and exceeding the constitutional requirements. And so I don't know if the sponsor or any members of the panel have a response to that concern that was raised in some of the written opposition that was filed in this matter.
Well, obviously I disagree with that. I don't, and you know, the case law is already available on the interpretation of the Constitution. But we do have a state's attorney. We do have law enforcement here today with Madam State's Attorney Marilyn Mosby. And so I'd like for her to address that question, if you don't mind.
So the one thing I will just add is that there have been 33 other states across the country that have codified these protections. And so this idea, and I'm sure that you'll hear from those that oppose this legislation when we're finished, this idea that we are following the law and that's sufficient, I would argue that that's not sufficient. And the science has told us it's not sufficient. When we look at, just the makeup of these children, why not? What is it hurting? How is it hurting us to ensure additional protections for children? And so that go beyond what the law currently imposes. And so again, if you're concerned about the constitutionality, this is something that's codified in 33 other states, and they follow the Constitution as well.
The Constitution requires a knowing and understanding waiver. I don't think any of us can truly say that a 14-year-old child or a 15-year-old child understands and appreciates the rights. He may or she may understand the words, but understanding the words doesn't give you the maturity and experience to determine whether there should be a waiver. So I would suggest the Constitution requires this.
And the only other point that I will make that is going to be brought up for you all to consider is that the law and these judges already make these considerations, right? There's some are going to argue that the age and the maturity and the characteristics of the children are always, or the totality of the circumstances are always going to be considered. But why wouldn't we codify this? We're going to rely on these judges. And I have all the confidence in the world in judges, don't get me wrong, but in every jurisdiction, they may treat or consider these circumstances differently. We should have across the board one consistent sort of protection when it comes to our children.
I would just follow up briefly. Thank you, Delegate Williams. One of the arguments is that this goes beyond the Constitution. That's just not true. Miranda set a floor, and it set it 50 years ago, and it set it for everybody. It set that floor before juveniles were even, or before young people were even guaranteed a lawyer to represent them in court, which happened the following year in Ray Galt. Miranda sets a floor, and what we know from the overwhelming research is that that floor is inadequate for kids, and that's why we're asking you to help protect kids, because we know that the floor established by Miranda is inadequate for kids, and we know that because of all the things we've learned over the last 50 years about brain development, how children process, and how they are conditioned to comply with authority figures.
If I may just add one sentence and one excellent sort of piece of evidence for the fact that we know that the current scheme is not working are all the cases we've discussed today, the Central Park 5, the Harlem Park 3, right, Alan Chesnut. These are false confessions that would not happen if this bill were to be adopted.
Are there further questions for this panel? Seeing none, thank you all very much. Go on through the regular order of the witnesses that are on the list. Carol Stern, Justin Nally, Lauren Lipscomb, Nick Maroney, and Michelle Feldman. See Carol Stern. We'll begin with her for 2 minutes, please. Witnesses that are on the list. Carol Stern.
Yes, thank you.
Please, for 2 minutes.
Thank you. Chair Clippinger, Vice Chair Atterbury, and members of the committee. My name is Carol Stern. I live in Chevy Chase in District 16. I'm providing testimony in favor of HB 355. I provide this testimony as a mother, a grandmother, and co-chair of the Justice System Reform and Immigrant Rights Team of Jews United for Justice. JUFJ organizes the Jewish community to fight for racial, economic, and social justice in Maryland and DC, and engages more than 5,500 people across the state. The Jewish text that shapes my religious and moral conviction that juveniles must have a right to counsel is the directive from Deuteronomy, Tzedek, Tzedek, Terdof, justice, justice shall we pursue. The Jewish sages explain that the word tzedek is repeated not only for emphasis, but to teach us that in our pursuit of justice, our means must be just as well as our ends. We are working to reform our criminal justice system, and we must demand that it operates in accordance with this deeply held Jewish belief. As a mother of 2 children and a grandmother of 3, I cannot imagine allowing my children or grandchildren to be interrogated by police without prior legal consultation and parental guardian notification. This lack of justice should no longer be allowed in our state. A juvenile may not understand their rights or the warnings given to them. Many may not have the education, experience, background, and capacity to even know they can stay silent or ask for an attorney or to call their parents. HB 315 adds much needed reforms for treating minors in the justice system with equality and the respect that all people deserve. I respectfully urge a favorable report on HB 315. Thank you.
Justin Nally.
Good afternoon, Chair, Vice Chair, and members of the committee. My name is Justin Nally, Policy Analyst at the ACLU of Maryland. The ACLU of Maryland supports HB 315, which is innocuous legislation that protects the due process rights of children. In this country, we protect children under 18 from themselves because we know children do not have the capacity to make long-lasting, life-altering decisions, regardless of their individual intellectual development. We protect children from gambling, buying tobacco and alcohol, and entering into law enforcement. We are responsible for ensuring children are not abused or manipulated by adults who can take advantage of a child's unknowing nature. This legislation ensures that a child's constitutional rights are invoked before a custodial interrogation occurs and that a child is automatically provided the access to consult with an attorney. This bill also fits into the larger conversation of police reform. We cannot rely on the assumption that an 8-year-old child will remain silent or that a 17-year-old knows their rights with a police interaction. We protect children in all areas of their lives. This legislation is the extension of that practice. HB 315 is a moral compass for where we are as a state. I will ask, what is so wrong for a child to have access to an attorney before they are questioned? What is happening during these interrogations that police and prosecutors do not want us to know? When you're in a position of authority, it's easier to get a child to say and do what you want, which is why we're seeing millions of dollars, taxpayer dollars, to exonerees across the country because they were wrongly convicted as children. We urge the committee a favorable report that this bill goes up for a vote to continue to protect children in Maryland. Thank you.
Lauren Lipscomb.
Good afternoon. Thank you, Mr. Chair, Madam Vice Chair, and committee. I appreciate the opportunity to testify in support of House Bill 315. My name is Lauren Lipscomb. I am a career trial prosecutor who began in the Baltimore City State's Attorney's Office 18 years ago as a law clerk and now have the privilege of being the chief of the Conviction Integrity Unit. I'm also proud to co-chair the Conviction Integrity Committee for the Association of Prosecuting Attorneys alongside my counterparts in Brooklyn, New York, and Philadelphia, Pennsylvania. To that end, I've had the privilege of presenting and participating in ongoing trainings covering all facets of conviction integrity work for prosecution offices across the country. I am humbled to be frequently called upon by other jurisdictions such as Connecticut, California, Washington State, to name a few, for insight into our unit while seeking advice on how to develop and execute their conviction integrity units. Here in Baltimore, I've led the investigations resulting in the exoneration of 10 men convicted of crimes that they did not commit, with our most recent release being in December 2020. In investigating these cases, I perform a sort of case autopsy in order to determine how to best direct each investigation. What emerges doing this work are flags that can be used to inform measures to prevent erroneous convictions. One of the flags is when juveniles are interviewed either as suspects or as witnesses without a legal guardian or attorney present. I will highlight two main concerns. First, it is apparent across the board that juveniles do not have the developmental capacity to exercise their rights when engaging with police. I've observed that interview safeguards that might work for adults do not with juveniles. For me, the same reasoning employed to prohibit juveniles from entering into a contract to buy a car, resulting in a 3 to 5 year commitment, or to get married without parental consent, resulting in theoretically a life commitment. The same reasoning applies to juveniles engaging with the police department, which may result in years of incarceration. What I have observed with when juveniles are interviewed alone are that they are easily led by police. They tend to answer questions primarily concerned with a short-term personal goal, such as saying whatever the police want to hear to get back home and perhaps play video games or other things that kids do. Secondly, I've observed that the detrimental impact of unfettered contact with the criminal justice system as a witness or otherwise as a juvenile is significant. Anecdotally, the exoneration of the Harlem Park 3 last year, which investigation I led, the police not only arrested 3 16-year-old suspects and interrogated them without their parents.
Ms. Lipscomb, if you would wrap your testimony
I
up.
certainly will. Thank you. Not only did they arrest 3 16-year-old suspects and interrogated them without their parents or an attorney, but our 4 states witnesses were 13, 14, 15, and 16 and were repeatedly picked up by police. One of our witnesses, who is 52 years old at this time and now serving a life sentence, laments that he never recovered from that year. He described being a solid student prior to this incident. Then that year, thank you.
Please.
To end,
Yes.
my goal is to ensure everybody involved is justly treated. And thank you very much for your time. And
Thank
I
you.
would ask for a favorable report.
Thank you. Nick Maroney, please.
Good afternoon, Chair Klippinger, Vice Chair Atterbury, members of the committee. Nick Maroney here to support HB 315 on behalf of the Independent Juvenile Monitor's Office, which is also called the Juvenile Justice Monitoring Unit. The JJMU operates out of the Attorney General's office and works to safeguard the rights of Maryland children and young people incarcerated in DJS detention and placement facilities. Our work involves frequent unannounced visits in order to ensure these young people receive the services they are entitled to and that they're not abused. Our reports are available on the Office of the Attorney General website and can easily be found by Googling JJMU OAG. Protecting our sons and daughters and trying to make sure that they're not left unprotected and vulnerable to manipulation or coercion is, I know, considered a sacred duty by all of us. Sometimes, however, young people are left alone with sophisticated adults in situations where they feel under duress and where there's a strong urge to comply with the wishes of adults who have their own agenda. At times, this agenda arguably falls within the best interests of the young person. I would argue, though, that when an unrepresented young person is in custody and being interviewed by police officers in an attempt to glean information, we're looking at a situation where there is an unconscionable misbalance of power. How can that not be the case when adults in the same situation are informed as to their rights to have an attorney present? This is a recognition of the legal jeopardy faced by the person being interrogated. Aren't children and young people entitled to the same recognition through the use of language that they can easily understand? I mentioned earlier feelings I believe you share about the need to protect all children and young people to prevent their being exploited or victimized. How would we feel if we learned late that our child was in custody and had already been held in question by the police without our knowledge and without anybody to advise or advocate on their behalf? I think I know how we would feel. The Irish have a saying, fit to be tied. Let's roughly translate that as absolutely livid. Who can argue that young people should be left hanging out there in such a precarious situation? No one. As adults, we have protection when we are with the police, and crucially, we are highly cognizant of these protections. We understand the Miranda warning and feel empowered to utilize our rights under Miranda if need be. We know we can ask for professional legal help.
Mr. Maroney, please. Mr. Maroney, if you would please wrap your testimony up.
Yes, we know that we don't have to spill our guts, and answer every question asked by an adult in a position of authority. We know we can stay quiet. Children are not so self-aware and usually have not developed a sufficient level of confidence to defend their best interests in such a predicament. I'll say this, and I'll leave it there. We should be helping kids in this situation at a time when they most need are entitled to the same protections as adults already enjoy and understand. And so I humbly ask that you please support and actually champion House Bill 315. Thank you.
Thank you very much. Michelle Feldman, please, for 2 minutes.
Thank you. Good afternoon, Chairman and members of the committee. My name is Michelle Feldman, and I'm representing the Innocence Project, and we're a national organization that works to address and prevent wrongful convictions. We support this bill because it would provide important protections against wrongful convictions of young people in Maryland. False confessions contributed to nearly 1/3 of DNA exonerations in the US since 1989. And in almost half of those cases, the person who falsely confessed was under 21 years old. So this bill is really about justice and public safety, because when an innocent person is convicted, the actual perpetrator remains undetected to potentially harm others. And just to wrap up, this bill would protect against false confessions and statements from young people that may lead to wrongful convictions of children. And we hope that you'll support it. Thank you.
I believe that is the 5. Are there questions for the panel, the vice chair?
Thank you, and thank you all for being here. I really wanted to say hi to Ms. Lipscomb because we went to school together back in the day. So I wanted to say hi to her and thank you for testifying on this. It's great to see you.
You as well, thank you.
If there was anything else that you wanted to share with us that you might not have gotten to.
I appreciate that. Thank you. I did want to share that the anecdote relating to the Harlem Park 3, the ongoing effects of contact with the criminal justice system that is unfettered, with like what we saw in that case, where the police and the state's attorney's office repeatedly went into the neighborhood and pulled these kids from school and pulled them from hanging out outside without notifying their parents. The effects that we observed 36 years later in interviewing those kids now were really profound. As I touched upon during my testimony, the one witness who is now 52 years old, there were intermittent tears for him relating back to the treatment that he and the other witnesses experienced during that year, that he was a good student. He really loved school. He respected police officers. He felt good about just our system and just how society operates. And that year changed everything. And it was his contact with the criminal justice system as a juvenile and as a witness. And so what I think is so important about this bill is not only affording juveniles adequate, it's clear to me in observing both them as witnesses as well as suspects that juveniles do not have the capacity to navigate the rights that they have, or to enforce or to raise their own rights when confronted with dealing with the police. And I don't know why we would treat this scenario any different than we would any other life-altering or life commitment that where we preclude children from entering into things like sales without parental consent. And lastly, I appreciate the indulgence. Lastly, what was very concerning to me was that what I think what this bill would be particularly effective with is perhaps equalizing the opportunity to have not only parents or a legal guardian or an attorney, combination of all, across all socioeconomic and demographic groups. What I did wonder when investigating the Harlem Park 3 case was whether the police would have acted in the same manner, perhaps if they were interviewing children who were in a different, not in West Baltimore, but maybe at the pool in Mays Chapel. I did wonder to myself how the differences, the interfacing between the police may have been different, and whether they would have automatically gone and sought the parents. And so I just leave you all with that. And I really do, our office really does support the intent of this bill, and we would hope that it would pass favorably. Thank you so much.
Thank you.
Delegate Anderson.
Yeah, thank you, Mr. Chairman. And my question is of Ms. Lipscomb as well. Ms. Lipscomb, how are you doing today?
Hi, how are you? Good to see you.
It's good to see you too, ma'am. On line or page 4, line 19 of the bill.
Yes.
Basically, and this is like, I think the guts of the bill, says that a law enforcement officer may not conduct a custodial interrogation of a child until, and it gives two conditions. The child is consulted with an attorney who has been retained by the parent, guardian, or custodian, or provided by the Office of the Public Defender. And then the law enforcement officer is notified or caused to notify the parent, guardian, etc. My question to you is that, is this sufficient? The child has consulted with an attorney. Don't we want the child to have consulted with the attorney and have the attorney present during any custodial interrogation?
I would say absolutely that we would want to even take that additional step. I think that that would be highly advisable, given that I know that following the last panel, there were questions about the whether or not a child might be in foster care, or whether there are circumstances where the parent also may not know to seek counsel. And so I would agree that I just to make sure that the rights of the juvenile are protected, I would agree that we might even want to take it one step further. Yes.
All right. I mean, I don't see the point of allowing the police to interrogate a child in a room with a child, you know, the 10-year-old or 8-year-old child by him or herself after the child has consulted with an attorney.
Right.
The attorney leaves the room, and now the police come back in, and they can do all the things that some of the witnesses testify to in terms of psychological manipulation, whatever. I would like to see that, and I hope you don't have any objection to that the child has been consulted and has an attorney available during all stages of the interrogation. My other question is, you are currently familiar with the practice of adults being arrested and having an attorney made available at no cost to them during their bail hearing, bail reviews, right?
Yes.
Okay, so right now in Maryland, any adult who is arrested there's an attorney in the courthouse ready to represent that adult in the bail hearing, the first phase of it.
Yes.
Would it be so hard to have an attorney present or available, just like we do for adults, for children when they are arrested or the police think they need to be custodially interrogated? Would that be any harder than what we're doing right now, you think?
I don't think that it would be. I don't want to speak out of turn because I have a very different experience in terms of the criminal justice system, where I have mostly dealt with adults and juveniles who have waved up into the adult system for one reason or another. But I don't believe that it would be more cumbersome.
Okay, no, that only answered the question because right now the child's attorney has to be one either retained by the parent or provided by the Office of the Public Defender. But I believe that the attorneys who represent adults prior to their bail hearings are provided by the court of the courts of Maryland. And Judge Morrissey knows. I think Judge Morrissey has set aside each year for the last 3 years $10 million to have that important function dealt with. And I think the same could be said or said of the need of juveniles. Thank you.
Yes, yes, I would agree. I would agree with that.
All right.
It's critical. Yep.
Thank you, Mr. Chairman.
Did I just see a $10 million fiscal note pop on this bill? Are there other questions for this panel? I don't think I did. Are there further questions for this panel? Seeing none, thank you all very much. Going to go.
Appreciate it. Thank you.
Hamza Ewing, Antoinette Kavanaugh, Catherine Hurley, Jeff Kukuka, Crystal Williams. Start with Hamza Ewing, please, as soon as Antoinette Kavanaugh. Hamza Ewing.
Yes, I'm here.
All right, if you would like to, where are you? Unmute yourself
Okay,
and we'll go for
certainly.
2 minutes. There you go.
Am I unmuted now?
You are, good.
Okay, hi, good afternoon. I'm Dr. Antoinette Kavanaugh.
I'm
Delegate
sorry, I
Bart-
was calling on Mr. Ewing.
I'm sorry.
It's okay.
I'm sorry.
Hamza Ewing for 2 minutes, please.
Thank you so much. Good afternoon. Thank you, Mr. Chairman, Madam Vice Chair, and distinguished members of the House Judiciary Committee. On behalf of the Council on American Islamic Relations, I thank you for this opportunity to testify in support of House Bill 315, entitled Juvenile Law, the Juvenile Interrogation Protection Act. The Council on American Islamic Relations is America's largest Muslim civil rights and advocacy organization. When police take a person into custody, they are required by law to advise them of their Miranda rights, the right to remain silent, and that anything they say can be used against them in court. However, Miranda rights do not apply to individuals who are questioned without being officially taken into custody, and the circumstances are drastically different when minors are taken into custody versus adults. Children are less likely than adults to be able to understand the complex legalities involved with submitting to questioning by police. Studies actually show that children are also far more likely than adults to make false confessions. A study of exonerations found that 42% of exonerated juveniles had falsely confessed, compared with only 13% of adults. As proven by the Central Park 5 case, uncertainty, intimidation tactics, and coercion in the absence of a parent or attorney, as well as environmental and personal factors, can induce fear and compel a child to misspeak, thereby compromising due process, leading to serious consequences and hindering justice. Children of color disproportionately over-policed and are far more likely to suffer adverse consequences and become entangled within the criminal justice system. Loopholes and tactics in policing practices further erode trust. It's a known fact that some police departments use questioning techniques designed to elicit confessions. CARE was actually alerted of one case in Maryland where a minor was told by an officer that he was free to leave and nothing that he said would result in an arrest that day. He did not have an attorney present and his guardian had not been notified. Police proceeded to charge him with a crime and take him into custody the subsequent day. In JDB versus North Carolina, the Supreme Court was asked to decide whether the age of a child subjected to police questioning is relevant to the determination of being in police custody. In that case, a 13-year-old seventh grader—
Mr. Ewing, if you would please wrap up.
Okay. So I just wanted to say that CARE strongly supports protecting due process for Maryland children, and we respectfully urge a favorable report. Thank you for your concern.
Thank you very much. Dr. Kavanaugh, now 2 minutes. Antoinette Kavanaugh.
Sorry.
There we go. 2 minutes, please.
All right, I'm Dr. Antoinette Kavanaugh. I'm a forensic clinical psychologist. For 10 years, I was the clinical co-director of the Cook County Juvenile Court Clinic, and I've been in private practice for over 20 years. Empirically, we have known about youth's inability to comprehend Miranda rights since 1980, when Dr. Thomas Grisso published the first study in this area. Beginning with that study and replicated numerous times over, research has demonstrated that for youth, more exposure to Miranda does not equate with increased understanding. Research in this area is fundamentally different than real-life encounters. Specifically, researchers have yet to replicate the stress associated with police encounters and deciding whether or not to waive one's rights. However, using fMRI data researched by Adriana Galvin and others have demonstrated that when stressed, youth's brains function differently and are less efficiently. Based on this, I contend that a youth's understanding is magnified when they are actually interacting with police because of how their brain functions and how it relates to stress. As an example of the research exploring youth's understanding of Miranda rights, I'm going to highlight a study that was conducted in 2017 by Sharif, Rogers, and Williams. They used hypotheticals and asked youth to demonstrate their logic for waiving or not waiving. The subject population was really important in the study. All of the youths were already legally involved. On average, they had 4 arrests. They were 15 years old and in the 8th grade. Now, if you remember, when you're in the 8th grade, you should actually be 13 to 14. So this suggests that many of these youths had repeated a grade, which is typical of youths in the juvenile justice system. 75% of these kids waived their rights. Now, remember, they're already involved in the justice system. 50% said they did so because they thought the police would think they were guilty if they remained silent. 2/3 could not identify a favorable reason to exercise their right to silence, and just as many could not identify a favorable reason to request an attorney. 31% were more concerned with short-term consequences, such as making the police upset if they waived their right. While
Dr.
only
Kavanaugh,
13, yes.
If you would please wrap up your testimony.
Yeah, only 13% recognize the long-term consequence. Research has consistently demonstrated that youth cannot understand their Miranda rights. And it is this lack of understanding that makes it so important that this bill is the reason that I can so wholeheartedly support this bill. Thank you.
Thank you very much. We'll go to Catherine Hurley, please, for 2 minutes.
Thank you. Good afternoon. I'm Katie Hurley, and I'm testifying today on behalf of the King County, Washington Department of Public Defense. I've been a public defender for the past 14 years, and during that time, I've represented thousands of children charged with crimes in juvenile court. Last year, as I finished another youth rights presentation, a 15-year-old here in Seattle who was living in a group home looked at me in disbelief as I explained his constitutional rights. At the end, all he said to me was, "That's not how it works." I tried to protest and explain the law and the Constitution, but he was right. I'd watched too many videos where I saw an armed police officer interrogating a scared child in the back of a patrol car. Rights were read like it was the Indy 500, and a youth, a child, usually a Black child, an Indigenous child, a child of color, was then interrogated by that armed police officer. Last year, here in King County and Seattle, we enacted the My Chance Dunlap Giddens Youth Rights Ordinances. These ordinances prohibit officers from questioning youth under age 18 after Miranda warnings are administered, unless they've spoken with a lawyer who can explain their rights and talk with them about what that really means and what they really want to do. The ordinance also prohibits officers from requesting permission from a youth to conduct a search, unless the youth is able to consult with an attorney. Our local legislation also has an exception for limited questioning if officers believe information is necessary to protect life from an imminent threat, and when a delay would hamper that. We currently have pending legislation in Washington State House Bill 1140 to provide access to counsel for youth statewide. As Seattle's mayor said when our local ordinance was enacted, we should never fear and always demand that any person know their full rights. This is particularly true for our youth. Our actions tell our young people whether we truly seek justice. Thank you very much, and I'm asking for a favorable report to advance this bill.
Thank you very much. Jeff Kukuka.
Yes, thank you, Mr. Chair. Good afternoon. My name is Dr. Jeff Kukuka. I'm an associate professor of psychology at Towson University, and I specialize in the scientific study of wrongful convictions. To quote the Supreme Court's 2011 ruling in JDB versus North Carolina, children cannot be viewed simply as miniature adults. Rather, the scientific evidence clearly indicates that juveniles are cognitively, socially, and neurologically different from adults in ways that impede their legal decision-making. As such, I firmly believe that the safeguards provided by House Bill 315 will benefit the administration of justice in Maryland. Opponents of this bill may believe that the standard Miranda warning is easy to understand because they themselves can understand it. However, the science tells a very different story. Research has consistently found that juveniles often forego their constitutional rights simply because they lack the necessary vocabulary to understand them. Accordingly, in 2010, the American Bar Association urged legislatures to support the use of simplified Miranda language with juveniles. And as Attorney Mosby pointed out earlier, many other states have since followed suit, demonstrating that it's feasible to do so. Opponents of this bill may also claim that a child's physical maturity is reflective of their psychological maturity, but that simply isn't true. Relative to adults, juveniles are more vulnerable to social pressure, especially from authority figures. and their underdeveloped brains often lead them to make short-sighted decisions like drunk driving or engaging in unprotected sex. In the interrogation room, these same factors render juveniles more likely to make false statements to police, including false confessions, which derail criminal investigations and leave the true perpetrator free to reoffend, which they often do. In sum, this bill presents a vital opportunity to base our policies on science rather than on intuition or anecdotes, and in so doing, to improve public safety by protecting against miscarriages of justice. I therefore welcome your favorable consideration of House Bill 315, and I welcome your questions.
Great, thank you. Crystal Williams. Crystal Williams here. All right, not seeing Crystal Williams, that's okay. If she comes later, I'll figure it out. Let's take questions for this panel. Delegate Anderson. Oh, I'm sorry, I just did see Crystal Williams. Crystal Williams, are you available to speak? There we go. Minutes, please.
Good afternoon.
Go ahead.
Thank you. Good afternoon, Chairman and members of the committee. My name is Crystal Williams, and I am the Director of the Government Relations Division for the Office of the Public Defender. I'm here today in support of this bill as one of the top priorities for our agency, given the broad implications and impact this would have on those we represent, and because it is simply the right thing to do in a time where our history and fellow states are replete with laws and judicial recognition that children under 18 cannot be viewed simply as miniature adults, and that it is time for Maryland to start taking heed and protecting their legal rights. Supporting a bill that ensures legal protections are implemented and upheld for children and adolescents subject to custodial interrogations should not be controversial. Understanding that children and adolescents are fundamentally different from adults means that they should not be treated, viewed as adults, whether they are 7 years old or 17 years old. This bill serves to codify existing legal protections for children under 18 through long overdue acknowledgement and acceptance of the dangers and risks that custodial interrogations present for children accused of crimes, and especially for Black children and youth. We must not forget the horrific case of George Stinney Jr., who was exonerated 70 years after he was executed at the age of 14 on the grounds of a false and forced confession. While today we continue to see traumatic news coverage of young children being handcuffed through tears and temper tantrums, thrown to the ground or physically assaulted and restrained, pepper sprayed and tased or shot and killed, the United States has a sordid history with children and adolescents in the criminal justice system, particularly Black children. Today, there remains a desperate need for reform and reckoning with how children are treated with desensitized cruelty and a lack of legally mandated specialized care. The question and issue at stake is not one of guilt or innocence, truth or deceit, right or wrong. What is at stake is the ability for children to understand the words and meaning of Miranda warnings, to know when they apply and to know when they can be waived. The stakes of getting it wrong has and continues to cost our society by doing irreparable damage to victims unable to get closure due to inadmissible statements and evidence, irreparable damage to falsely accused individuals, exposure and critical time lost and corrupted behind bars, irreparable damage to the broken trust between law enforcement and the communities they are sworn to serve and protect. It is time for Maryland to make a commitment to upholding the basic legal principles and the deeply embedded constitutional rights, and ensuring that all children and youth understand their constitutional rights and protections when being confronted with the inherently involuntary and coercive requests to give up those rights and protections. Thank you.
Thank you. All right, now we'll have questions for this panel. Delegate Anderson, please.
Yeah, thank you, Mr. Chairman. My question is of Dr. Jeff Kakucha. Is that correct? I'm sorry.
Kakuka, yes, sir.
Kakuka. You continually referred to the interrogations being done in an interview room, but in fact, I would assume that you know that they're probably done, as someone else mentioned, in the backseat of a patrol car, could be in the child's living room with other siblings being detained. The child could be handcuffed to a bench in a hallway in the police station. All of these things are fairly intimidating. And the point of my question is I'm trying to get to where the bill would say, rather than just allow the child to consult with an attorney, but to say that a child must have an attorney present during all phases of a custodial interrogation. That seems to me it would simplify things so that regardless of where the interrogation occurs, the child is guaranteed the right to have an attorney there, not just to consult with and then to be interrogated, but to have the attorney there at all phases. Would you agree or disagree with that?
I completely agree. In an ideal world, the attorney would be present, not merely a consultation would occur and then the juvenile would be interrogated or questioned alone. That said, I still see this as an important step in the right direction. Some consultation, in my view, is certainly better than none.
Well, I'm one who's willing to take a step in the right direction, but since we got it here, we might as well complete the deal and take all the steps necessary.
And I would absolutely support such a measure.
Okay, and Ms. Hurley, can I ask one more question, Mr. Chairman?
Sure, I'm going to ask a question based on yours in a second, so go ahead.
Okay, I'm glad to see Ms. Hurley back. You are an attorney in Washington State, right?
Yes.
Okay, because I thought for some reason you said Kent County, I misunderstood that. So currently now, we're in Washington State, you use the word to consult with an attorney. How does it work when a child consults with an attorney? Is the attorney there during the entire interrogation, or does the child get like a half hour or so or 20 minutes with an attorney?
Thanks for your question. So the way we have it here in Washington State is I'm in Seattle, Washington. And so in Seattle and for the King County Sheriff's Office, so we have this protection in place in Seattle and King County. And then we have statewide legislation pending to apply it to the whole state. But how it works with our local ordinances is that before the officer can interrogate the child, they have a consultation, which typically happens by phone. But we also have a provision that the youth can obviously assert themselves, but the attorney can also communicate that to the officer. And that came out of times where I would see a cop interrogating a young person, sometimes in our juvenile jail, in our juvenile detention. And I would speak with the young person and give them advice. And then I saw it was very hard for them to then assert their rights to the officer, and it was extremely intimidating for them. And sometimes the officer wouldn't take an assertion that I made. They said they needed to hear it from the kid. And so I think it's, in our local ordinance, we have it explicit that the attorney is able to speak with their client, the child, and then assert on their behalf.
The attorney?
Yes.
Okay, thank you. Thank you, Mr. Chairman.
Thank you. Are there other questions for this panel? I have a question for Crystal Williams, please, from the Office of the Public Defender. Last year, in the testimony that was brought forward regarding this legislation, the representative of the Office of the Public Defender indicated that there would be a sufficient number of public defenders to provide legal counsel to juveniles who were questioned under this. And Delegate Anderson has on several occasions, and perhaps rightly, compared that to the attorneys who are present in the commissioner's office at the time of the first bail review. There are 33, I believe, district court offices that have commissioner's offices in them statewide. Can the Office of the Public Defender tell the committee whether they have enough state public defenders to be able to staff each one of those commissioner's offices across the state, starting when this bill became law? Not saying that this, in fact, and let me be clear, this bill does not, in fact, say that right now. But if there were a change with that, would the Office of the Public Defender have existing current resources to be able to put attorneys in each one of those offices for the times when children are interrogated?
So thank you, Chairman Clippinger, for that question. And what I will say, and again, I will remind the committee, is that this bill is actually a top priority for our office. And I know that Mr. DeWolf has committed to making sure that this effort works and that the Public Defender's Office ensures that we are able to make it work. And so he has given us our commitment to do what we need to do to make sure that all children are adequately represented with the passage of this bill. And so whether that is through a hotline number, whether that is through putting individual attorneys into individual offices, that is something that we are committed to resolving and making sure that it does work. And I know that there are currently efforts underway at the Baltimore City level to make that work, and we're looking at ways to expand that. But I do know that there is a full commitment by our agency to ensure that there are attorneys available and present for any child that needs consultation and representation with the passage of this bill.
And I'm going to go to your point on making the attorneys available perhaps through a hotline. It seems to me in the legislation, now shifting to the legislation and not necessarily into providing attorneys in places all the way across the state, a physical attorney everywhere. I believe that the bill, or at least different incarnations of the bill, would allow for a consultation with an attorney to be done by teleconference, by voice call, by video call. And I think we've learned through COVID how important it is to have that option available. The question, I guess, going back to Delegate Anderson, and Delegate Anderson and I have known each other now for almost 12 years, and I'm not going to pick on Delegate Anderson much more than his recommended daily allowance. But having said that, my question is would effectively a televisit from an attorney be sufficient in these cases? It strikes me that they would have to be sufficient, certainly under what we're going through right now with COVID. But are you advocating that you would want? I mean, you have said, and others have said, what's more important is to actually have an attorney there. Is that ultimately the ultimate goal here?
So, Chairman, is that a question directed to me again?
Yeah. Mm-hmm.
So, to answer your question, certainly the ideal would be to be physically present. But the bill is specifically flexible in that it does allow for telephone or video conference. And as you stated, during this time of COVID-19, there has been an expanded use of video conference, and we currently utilize that to have confidential conversations with our clients who are currently incarcerated. So that is a sufficient and confidential means to have conversations with individuals that are currently in custody. So it absolutely would be a sufficient means under the bill.
Thank you very much. Are there further questions for this panel before I move on? Seeing none, thank you all very much. We're going to go. There are, I believe that we have, I'm looking at my list here, 4 people who are in the waiting room who are signed up and are ready to go. So we're going to go ahead and call them. John Comer, James Dold, Abby Stout-Miles, David Young. There are others who have signed up to testify but are not in the waiting room. Consider this your, okay, and we have also Kay Thomas, who also has just joined us in the waiting room. She can come in for this panel, and that will make 5. There are 3 people not yet shown up in the waiting room. Nicole Hansen Mundell from Out for Justice, Ashley Devon, and Marlon Tillman. We will keep an eye out for them. We're going to go ahead and hear from these 5 people, and we'll do another panel if any of them show up. Although if only maybe one of them show up, I would like to try to fold them into this final panel so that we can keep moving here. But with that, Kay Thomas is the first on the list. Is Kay Thomas here? I see her in the waiting room. I understand that Ms. Devon had a family emergency and won't be here today, and I hope everything's going well with her family, so we will not wait for her. And okay, Ms. Thomas is working on her audio. We'll come back to her. John Comer?
Yes, good afternoon.
Right, 2 minutes.
All right. Good afternoon, Mr. Chair, Madam Vice Chair, elected officials. My name is John Comer. I'm here with my group, Architects of Justice, as well as part of the Reimagine Youth Justice Coalition. I'm based out of Baltimore. Community organizing is my background, organizing in West and East Baltimore for years now. And I asked for a favorable vote on HB 315, but to put it simple and plain, child interrogation is child intimidation. And I'll tell you one of the many examples of why I say that. The presence of police in the Black community many times have caused trauma, and it ends up causing much harm to our community. And so one day while I was in McCullough Homes, which is a housing project on the west side of Baltimore, I was watching one of my members' sons, and he's about 6 years old. And as we're standing outside, the Baltimore City helicopter flies above, and he looks above up in the sky and he says, "Mr. John," he says, "why are the police always bothering us? We're not doing anything." And I was caught off guard by that question, because at that point in time, I really wasn't ready for a 6-year-old to be asking me that question. Now, he hasn't had any interactions with the police, but this is what happens when your community is consistently over-policed. And so you add that with the interaction of the police being able to pull kids to the side, take them downtown, and interrogate them, and then you end up having more trauma. And then we end up in another session with another bill trying to correct the trauma that was made systemically, right? So we can't continue to legislate these things and expect greatness to come from our kids across the state of Maryland, right? So, and I'm here much because the only reason I do this work was because as a youth, I was pulled over in the 5th grade, walking down the street and harassed by a police officer. So it's not like this is my calling. I had other things that I wanted to do in life. But because the system continues to jump in front of us, this is something that I can't ignore and I have to fight. So I ask for your favorable vote on HB 315.
Thank you very much, Mr. Comer. James Dold.
Thank you so much, Mr. Chairman, and thank you to Delegate Bartlett for introducing House Bill 315. James Dold on behalf of Human Rights for Kids here in support of this really important piece of legislation. At its core, this bill is really about safeguarding the constitutional rights of children, and nowhere is that more important than when we're dealing with children who are facing very severe consequences in the criminal justice system. The opposition will talk about the parade of horribles of cases, but this isn't about any one particular case. It's not about the punishment even that children who do commit these crimes should face. This at its core is about safeguarding children's constitutional rights and making sure that they understand what they're waiving when they do in fact waive their Miranda rights. To Delegate Anderson's question a little bit earlier on, the American Academy of Child and Adolescent Psychiatry has actually recommended that attorneys be present during custodial interrogations because of all of the research that has been cited to earlier in the testimony about how kids are more likely to waive their constitutional rights and how they fundamentally don't understand those rights. Similarly, the American Psychological Association has also encouraged the adoption of provisions very similar to House Bill 315 to make sure that children consult with legal counsel before they waive their rights, because again, they don't understand those rights. I'll also point out that from a fundamental human rights standpoint, Articles 37 and Articles 40 of the UN Convention on the Rights of the Child also specifically state that children should have counsel present and be assisted by a concerned adult during any custodial interrogation. This is one of the provisions that we looked at when we were rating all 50 states on how well or how poorly states were protecting the human rights of children. And as I've mentioned in my testimony before the committee, Maryland was one of the worst states in the country, so bad so that we actually labeled Maryland one of the worst human rights offenders when it comes to the treatment of children in the U.S. criminal justice system. And just to sort of put an exclamation on this particular point, I want to highlight data from the National Registry of Exonerations. When they were looking at data specifically around false confessions of children who were later exonerated, about 87% of children who were under the age of 14 falsely confessed to crimes that they did not commit. And this is sort of nationwide. Over 60% of 14 and 15-year-olds falsely confessed to crimes that they did not commit. And so again, this highlights the important nature of this bill and why it is necessary to safeguard the constitutional rights of children. And lastly, I'll just say
very quickly.
Lastly, from a victim advocacy standpoint, there's nothing worse that can happen to a victim than to know that a person who has spent decades in prison was wrongly incarcerated for a crime that they didn't commit, while the person who actually harmed them is actually out on the streets and not convicted. So this is also an important bill from the perspective of protecting the integrity of law enforcement investigations. I think that's another reason why Ms. Mosby and other prosecutors support these types of reforms, and we would urge this.
Thank you very much.
Thank you.
All right, Ebby Stout-Miles, for 2 minutes, please.
Good afternoon, Mr. Chairman and members of the committee. Thank you for the opportunity to support House Bill 315. My name is Ebby Stout-Miles, and I'm the State Policy Advocate for Juvenile Law Center, and I'm also the Vice Chair of Montgomery County's Commission on Juvenile Justice. I'm testifying in both capacities to urge the legislature to support this bill and protect vulnerable youth in our state. I have 4 points that I'd like to touch upon. First, a couple of examples of the current practice in action. In Maryland in 2019, there were 2 instances of police questioning elementary school children for playing with play money. Their parents were not notified until after the police asked the children questions and Secret Service was called. Even when questioning does not lead to an arrest, the potential trauma of the interactions for youth is significant. The protections in this bill are vital. It is so good because it's, in our opinion, that Miranda itself, in an attempt to contact a parent or guardian, just isn't sufficient protection for youth. The bill provides the protection of consultation with legal counsel to ensure that the child's legal interest is protected. Number 3, children should not be expected to understand concepts like their rights. Even if the police gave perfect Miranda warnings, and even if they taught kids all about Miranda, kids would still not fully appreciate the warnings because the warnings are too abstract and the kids are under stress and in a moment of hot cognition, where they are not making the most measured decision. This is why it's so important that kids have counsel. Number 4, kids are susceptible to coercion and false confession. Gaining a false confession by interrogating children without counsel enables the actual perpetrator to wander the streets. The likelihood of a false confession is too high to forego procedural safeguards. If we wish for Maryland to have a fair and equitable justice system, we must ensure that youth are not coerced and incarcerated simply because they are children and do not understand their constitutional rights. The Juvenile Interrogation Protection Act would better protect children's rights and better meet their needs. For these reasons, we urge you to pass Senate Bill 136 and House Bill 315. Thank you.
Thank you very much. All right, we will go now to David Young, please, and then to Kay Thomas. David Young.
Good afternoon, Chairman Clippinger and Vice Chairman Atterbury. My name is David Young. I'm a retired judge of the Circuit Court for Baltimore City. For 35 years, I had the privilege of serving as a member of the Maryland Judiciary. 12 of those years were spent in juvenile court. In my capacity as a juvenile court judge, I had many occasions to preside over serious allegations involving juvenile offenders, which gave me great pause as to whether or not the accused was actually being afforded any reasonable measure of due process. And I would emphasize, as you're aware, juvenile proceedings are different. An adult is about conviction, retribution, and incarceration. In the juvenile context, it's supposed to be about rehabilitation. This difference notwithstanding, I had numerous occasions when I saw children taken into custody and interrogated without having any notice being given to their parent and guardian, without having any opportunity to speak with that parent or guardian, without any opportunity to speak to an attorney. Rather than being treated as children, they were viewed often by the police as sophisticated individuals, when in actuality they were immature, frightened children who would say or do just about anything to end the interrogation, including giving false confessions. And I had instances where the public defender provided evidence that the juvenile could not possibly have been where they confessed or admitted to being. And so I would just close by saying that in a high stress environment of an interrogation room, this child or adolescent is far more likely to say anything, not just whether it's true or not, just to get the interrogation to stop. And they often ignore the long-term consequences of their decision. House Bill 315 comports with best practices from the International Association of Police Chiefs, and I would urge you in the strongest possible terms to please support this bill. Thank you for the opportunity.
Thank you very much. We're going to go now to Kay Thomas, and also Marlon Tillman has entered the room. So we'll hear first from Kay Thomas, then we will go to Marlon Tillman. Kay Thomas.
How y'all doing? Greetings, members of the panel. My name is Kay Thomas, and I'm gonna start my testify by saying the police will violate our rights by not always having our attorneys or parent present during the interrogation process. The police will try to get us to tell on one another. The police try to feed us so many lies and tricks just so we can tell them what they need to know. They try to force things out of us. That is not justice. That is outrageous. That is no justice. The police just want to get what they want to know, just so they can get their conviction and their check. It's take your time. I feel like the court system is set up for us to fail. Like I know this because I've been through the court system where my rights were violated, and I'm asking the panel to support this bill.
Thank you very much, Mr. Thomas. Thank you. There we go. All right, we're going to go to Reverend Tillman next. Reverend Marlon Tillman, please.
Good afternoon, Delegate Luke Clippinger and members of the House of Judicial Committee. I'm speaking on behalf of Bridgemill Incorporated, a statewide faith-based organization, and we are in favor of House Bill 315 with amendments submitted by the sponsor of the bill. It was former President Hubert Humphrey who said that the moral test of government is how that government treats those who are in the dawn of life, the children. And it was Nelson Mandela who said, there is no keener revelation of a society's soul than the way in which it treats its children. And it was Reverend Dr. Martin Luther King who summarized these international leaders by saying, the law cannot control how people regard each other, but it can mandate how people treat each other. And as a parent, grandparent, mentor, uncle, and pastor, Scripture reminds me, do not worry about anything. Instead, pray about everything. Tell God what you need. Then you will experience God's peace. However, I do worry whenever a vulnerable child leaves my sight. I pray, like most of your constituents, that if they had a bad encounter with the police, they will receive due process. I pray that a legal representative will care for a child's words because what they say could alter their lives forever. And I pray that Miranda is written for the 21st century to recognize our child's maturity. And whether you share my titles as a parent, grandparent, uncle, or mentor, please remember this. Children are our grantors. They are a crown to the aged, and parents are the pride of their children. See that you do not despise one of these little ones, for I tell you that their angels in heaven always see the face of my Father in heaven. Thus, you are granted the power by your constituents to protect Maryland's children so that we don't have to worry and have peace of mind. We encourage you and count on you to vote in favor of this bill with amendments by the sponsor. Thank you.
Thank you very much. We'll go for questions now to Delegate Cardin.
Mr. Chairman, thank you. I actually was going to ask Judge Young a question, but I think I'm going to save it for the state's attorneys and ask them the question. But it's really great to see you, Judge Young, and I appreciate your perspective. Thank you.
Thank you. Delegate Anderson.
Yeah, thank you, Mr. Chairman. My question is going to be to Judge Young. First, Judge Young, I hope your tennis game has improved since the last time I saw you. That's a rhetorical question, but getting.
Wow. Please do not abuse the witness, Delegate Anderson. Move on.
He's been abused before, Mr. Chairman. But he's held me in contempt too, so at least he can't do that now.
Well, who hasn't done that?
Exactly.
Delegate Anderson.
Yeah, my question, though, Judge, is let's assume for a second that the Office of the Public Defender could get an attorney available for a child, either virtually or in person, because I think in person would be almost an impossibility, given the places where these interrogations could occur, not just in police stations, but in patrol cars or in living rooms, wherever. Would you prefer the attorney to be there just to consult as to whether or not the child should answer the questions, or should the attorney be there during the entire term of the interrogation?
I apologize for the phone, but in the background, I would suggest that the attorney be there, absolutely, if possible, whenever possible. But it's just so important that this represents at least a first meaningful step towards ensuring due process. So in a perfect world, the attorney would be present. But if an attorney can't be present, I think it's critical that they at least have the opportunity to consult with someone who can speak to them in an age-appropriate manner to make sure that they understand what their rights are.
Thank you, Mr. Chairman.
Thank you very much, Delegate. The Vice Chair.
Thank you, Mr. Chairman. I don't have a question. I just wanted to say hi to Judge Young. He gave me my first job as a law clerk when I graduated law school, where I got to witness firsthand his commitment to, quite frankly, the youth in our state. So it's really great to see you after a long time.
I'm proud of you.
Thank you. He used to stand up for me. He wouldn't let anybody give me anything, any drama, any trouble.
And now you're here. Are there further questions for this panel? Seeing none, thank you very much. Thank you very much. I actually had questions, I think, for the sponsor, but I think we're going to end up talking about this bill a little bit more. I might ask some of them here as well with the state's attorneys. We'll find out. So, okay, let's go now to those in opposition. And we will start. Mr. Schellenberger is virtually across the street, apparently at JPR. So Joe Riley, Jerome Spencer, Gavin Potashnik, Stephen Kroll, Troy Berry are the five. I see Mr. Riley has entered. We can go forward with Joe Riley. There he is. All right, Mr. Riley, for 2 minutes.
Morning, Chairman Clevenger, Madam Vice Chair.
Spencer, Gavin Potashnik.
Oh, well, we'll let you start over.
Thank you.
Go ahead.
Chairman Clevenger and Madam Vice Chair, members of the committee, I'm Joe Riley, elected State's Attorney for Caroline County and the Chair of the Maryland States Attorneys Association's Legislative Committee. I wanted to make sure that the Judiciary Committee understands that the MSAA objections to specific positions of this legislation should not be interpreted that we do not understand that there exists specific and recognizable differences between juveniles and adults. The proponents of this legislation say many experts on this area acknowledge it, and case law all the way up to the Supreme Court confirms it. Juveniles lack the capacity that adults have, and age is a relevant factor when determining legal issues such as custody. Children possess characteristics that make them unique and distinguish them from adults. Their lack of experience, perspective, and sophistication lend them to make choices that an adult would not make. They are more vulnerable to influence and outside pressures than their adult counterparts. While the MSAA has specific objections to parts of this legislation, for example, the age-appropriate Miranda, we believe, should be written by the Court of Appeals, since they're going to be the body that determines whether or not it's sufficient or not the NPTC. We, as an organization, look forward to working on specific amendments to this bill with Delegate Bartlett, who we would like to thank for her work in this area. We look forward to working on hopefully a law that will protect all juveniles and provide guidance to law enforcement officers. With that, I'm going to hand it over to my colleagues who are going to testify about specific provisions of the bill, Mr. Kroll and Mr. Potashnik.
Okay, well, let's do that. Let's go with Mr. Kroll, please.
Chairman, members of the committee, good afternoon. Stephen Kroll, the State's Attorney Coordinator for Maryland and the Executive Director of the Maryland State's Attorneys Association, in opposition to House Bill 315. But I do want to express to Delegate Bartlett my thanks to her for including us in the conversation. And if it happens on this bill or anything else, Delegate Bartlett, I'm always thankful that you're able to give us a say in what these bills are all about. So I just want to say thank you, and we'll continue the conversation. There really is a simple proposition to cure all this, to raise it above Miranda, and that is to videotape any interrogation between juveniles and the police. It's that simple. Any interrogation between the police and a juvenile must be videoed, body camera, something, and preserved at that point in time. And that solves any abuse that may be there. Very simply done. Now, the what ifs. What if a child kills his parent? What guardian do you notify? What if a child's in DSS custody? Imagine trying to get someone at that time. There's a blended relationship between a child and a minor stepbrother. What's the mother going to do when both are charged? Or the mother or the blended child and a stepfather, or again, a stepbrother. What's the mom going to do when they're notified? The chairman, 33 commissioners, but how many courthouses that interviewed defendants that are children? You're going to put a public defender each one of those? A fiscal note that's going to be outstanding, and I'm being nice by saying outstanding. Can't have that. Going to call some public defender or some private attorney like Delegate Anderson. And Delegate Anderson, at 3 o'clock in the morning, are you going down to talk to a defendant? I'd like to see that at 3 o'clock in the morning. I know you would at 3 in the morning. Many will not. Many will not. They'll just say, oh, don't say anything, hang up. That's the conference. Don't say anything, hang up. The easy way around it from there. In the meantime, there are certain things that we can do. As I mentioned, body cameras for all. The second thing, when it comes to imminent bodily harm, what happens if the juvenile says, I'm going to blow up something, or says something of fire? It's not imminent, it's something in the future. Not protected under this bill. What if there's an imminent bodily harm that goes to a future bodily harm that returns to an imminent bodily harm? Goes back and forth, back and forth. Try to do that in front of the judge at that point in time.
Mr. Kroll, you need to wrap up.
What I'm really offended about is I saw Mr. Dole, D-O-L-D, say that the state or the prosecutor is going to put forward, and he called it a parade of horribles. What happened to John Browning is not a parade of horribles. And Mr. Chairman, I'm spending this entire session trying to make words better and mean something. To call anything that the state does a parade of horribles is inappropriate and wrong.
Mr. Kroll, thank you.
We asked for an unfavorable report, but I look forward to working with Delegate Bartlett.
Thank you very much. All right. We'll go now to Mr. Potashnik. 2 minutes.
Good afternoon, Mr. Chairman, Madam Vice Chair, members of the committee. I too wish to express my thanks to Delegate Bartlett for bringing forth this issue. I understand it's an issue. I think I understand as an individual who has either defended or prosecuted juveniles for most of my career, and I've been practicing for 17 years, both as a private attorney and as a prosecutor. I completely understand that aspect of it, and I think it's an important issue, and I thank and I welcome the fact that the conversations we have. That being said, quite frankly, what I want to zero in on this bill is two aspects. One, I want to reiterate what Mr. Cole indicated, that I think that the Office of Administrator of the Courts or the judiciary should be the ones to decide the child-friendly language. I think they're the ones who determine whether or not it's in line with Miranda rather than the Police Service Commission or the Police Training Commission. Secondly, it strikes to me that there is no fiscal note on this bill from the Public Defender's Office. I have questions about who's going to administer this program. I have questions about who's going to resolve conflicts with the Public Defender's Office, who's going to recruit attorneys, who's going to train attorneys, who's going to do all the work necessary to provide the body of information that this panel is asking for. I don't think those pieces have been met yet. I know the Public Defender's Office indicated that they're working on it and they are committed to it, but I see no plan, and no one has provided me with a plan that will actually work. So, with that, I think that the fiscal note in this would probably be bigger if somebody would actually provide a plan as to what is the actual, process for resolving complaints. I would also note that when you look at the bill, you really have to look at in custody. And I think last year when we had talked about this, in custody for juveniles encompasses a wide variety of things. I think the behavior that people most often associate with custodial interrogation is putting a child in a room. But a custodial interrogation could occur if there's an interaction with law enforcement where a reasonable child does not believe they're free to leave. It's possible you have 5 or 6 kids where you're trying to find out information about where property is, or whose weapon this is, or something to resolve the situation, and each one of those children would be afforded under the statute an attorney. So how's that process going to work? Who's going to provide that? How much time is that going to take? And is that time going to force those children in situations where they're being held a lot longer than they should because they're trying to find attorneys for each of them? So with that, I have to report, and I thank you for your time.
Thank you very much. Now we'll go to Jerome Spencer and then to Sheriff Barry, or whichever of the two of you would like to go first. We'll go to Mr. Spencer. He showed up on the screen first. Sorry, Sheriff. Jerome Spencer.
He'll take it out of me later. So thank you, Mr. Chair. Thank you, Madam Vice Chair. I'm Jerome Spencer. I'm currently the General Counsel of the Charles County Sheriff's Office. I work for Sheriff Troy Barry. I'm here on his behalf, as well as the Maryland Chiefs and Sheriffs Association's legislative committees. I was a prosecutor for 16 years, was also a judge for 2 years before I was honored to work for Sheriff Barry. So what we have to say is going to sound an awful lot like what Mr. Riley said. First, we very, very much appreciate Delegate Bartlett having a conversation with us earlier this week. We had a very productive conversation, I believe, and Delegate Bartlett went a long way trying to calm some of the fears and concerns we might have about this bill. We very much appreciate that. In broad terms, the biggest concern we have with the bill as currently written is that it's one size for everybody. An 8-year-old is not the same as a 17-year-old. Not every 17-year-old is the same. And yet, with this bill, everybody in the age of 18 cannot waive without having the consultation with an attorney. Now, Delegate Bartlett said, and I think one of the panelists pointed out, there are 33 other states with similar laws. I've been able to find 11 of those 33 since our meeting earlier this week. There are 11 different ways of approaching it. There are multiple ways to reach the same goal. Ultimately, we share the same goals, which are make sure that juveniles' rights are protected, that juveniles are informed of their rights and understand their rights, and that any statement obtained is a voluntary statement. Those are the critical, important goals this bill tries to address, and we absolutely 100% share those goals. We think there are other ways to further those goals beyond the mandatory sweeping language of this particular bill. Thank you, Mr. Chair.
Sheriff Barry, please.
Good afternoon, Chairman and members of the committee. I'm Sheriff Troy Barry with Charles County Sheriff's Office, and I also have an opportunity to serve as the president of the Maryland Sheriff's Association. I'm here to express my concern regarding House Bill 315. This bill requires certain procedures to be followed when a police officer contacts a juvenile regarding criminal-related investigations. I just want to let the committee know that model policy already exists for the interview and interrogation of juveniles to ensure consistency, being mindful of the juvenile's maturity and also emotional development. These policies and best practice can be reviewed within several organizations, which is the International Association of Chiefs of Police, the Commission Accreditation for Law Enforcement, the National Sheriff's Office Association, and many other accredited organizations. Maryland law enforcement is very concerned about this legislation because it goes beyond model policy. If juveniles are arrested, they are not excluded from their Miranda rights. And all information that is gleaned, all information in regards to statements are analyzed and reviewed by our elected state's attorney's office and also judges. The courts are considering these particular factors when it comes to juvenile, their age, their experience, and characteristics. The Maryland law enforcement policies are adhering to the Miranda laws and clearly established by our state and federal courts. For these reasons and more, the Maryland Chiefs of Police Association and the Maryland Sheriff's Association are in opposition to House Bill 315.
Okay, there are several questions. We'll start with Delegate Cardin.
Thank you, Mr. Chairman. Thank you all very much. And this isn't to any particular individual, but whomever on the panel wants to handle it. This is not a hypothetical. This is an actual situation that occurred. There was a call, a 911 call from the grandmother of an alleged victim, a white victim, that 4 Black boys, age 13 and 14, were involved in a possible assault and theft. Police came 2 hours later. There was no emergency. There was no hospitalization. There was no call for EMTs. And my client was found on his front lawn across the street from the alleged place where it all occurred. The police officer took him, put him on the curb, made him wait there for 45 minutes handcuffed. They found the other 3 alleged perpetrators, put them all on the curb and handcuffed them. Then they took them in separate cars to the police station with lights going through red lights, sped them down, and put them into separate rooms and asked for their stories on this. By the way, it was a scooter. It was one of those hand scooters, $69.99 special at Toys R Us hand scooter was the alleged theft. The mother was inside the house and he was on the lawn 30 feet away. And they didn't bother just knocking on the door and saying, by the way, we're taking your son down to the station. They didn't tell him. He's 13 years old. So I'm not exactly sure why we're arguing about this. And Mr. Kroll, just with all due respect, the entire thing was on video. I had it all when I dealt with the case. So we saw exactly how they treated him. They never gave them, these young boys didn't understand that they were being intimidated and threatened and coerced into saying something, which, by the way, all their stories were 100%, in this case specifically, all their stories happen to have been 100% correct. I mean, consistent, and their corroboration was exactly the same. And in the end, they realized that this was a huge misunderstanding. And you think about the consequences to these 4 boys who never had an interaction with law enforcement before that, and God willing, they won't ever after that. But because of how they were treated and because they didn't have somebody advising them, they could have gotten themselves into some deep, deep trouble. And only because I think they were all very honest young boys, they wound up not getting into trouble. I just don't understand why we're even arguing about this. They should all have representation. They should all, every one of their parents or guardians should be at least know that they're going to spend the next 2.5 to 3 hours in the police station being questioned, you know, and scared to death. I'm sorry. Anybody want to comment on that situation and how that might have been improved with the policies that we have? And by the way, in Baltimore County, the entire the manual for the how you deal with witnesses has about a page and a half on dealing with juveniles. Page and a half total in a 128-page manual. So, I mean, maybe the training needs to improve something. I'm sorry. I apologize, Mr. Chairman. I just want to figure out why we're even arguing about this.
So Delegate Carton, if I may, I would respond by saying we're not arguing about everything, and I don't think we're arguing about a lot. Part of this bill, under the current law, the police are required to make notification to parents to take a child in custody. Under this bill, the police are required to take efforts that are likely to provide actual notice to the parents. That's not something that the chiefs and sheriffs are arguing about. We can think about particular examples where they might not be practical. But in the scenario you described, I've shared the reaction you described, that if mom is right there in the house, knock on the door and talk to mom. So my response is we're not really arguing as much as it may appear we are. That's why we're looking forward to continue to work with Delegate Bartlett and continue to discuss the issues.
And Delegate Cardin, I echo the sentiment too, that, I mean, we're not arguing that they shouldn't provide actual notice to parents. I agree with you. And I think that both the State Attorneys Association agrees with you. Everyone does. I know that when I teach law enforcement about juveniles, first thing I say is you have to get the parent. You have to get the parent. Most departments are either they have not, and I don't know how long ago that predicament happened, but I know that a lot of departments are moving towards policies which mandate parent involvement with any type of custodial situation, whether it's interrogation or not. So again, we're not arguing that component of the bill. Leave it at that.
In the scenario you're describing, Delegate, I think we're in agreement with you, and I don't think you have to characterize our position as we're arguing with you on it. I think everyone on this panel would agree with you on that scenario that you've given.
All right, the Vice Chair.
Thank you, Mr. Chair. And first, I want to thank Delegate Bartlett. I didn't before when I was just saying hi to Judge Young, but for bringing forth this legislation. Next, I want to thank Mr. Spencer, because you are the only one that started off with, you know, we're trying to work towards a common goal. We share these goals. So I appreciate that. I appreciate not being yelled at. When we're talking about a parade of horribles, the parade of horribles that we have to deal with is watching on video a child calling for her father recently. I'm sure everyone has seen this, and she's being arrested. It was a mental health call. She's in the car calling for her father. She won't swing her legs into the car, and she's handcuffed, and she's literally crying for her father. I mean, when we're talking about a parade of horribles, we're talking about the Central Park Five. We are talking about children. And so those are the parade of horribles that I'm worried about, quite frankly. And quite frankly, when we talk about justice and we talk about justice for children, whether it's child abuse or human trafficking, I kind of put this in the same category. Children have rights, they're people, they're humans. And, you know, I think about my children, as I always do, and when I'm looking at legislation, and I can't imagine a child trying to comprehend and understanding their rights when put into that situation. A reasonable child is not going to understand their rights. They are not going to understand what they have to do in that situation. We have had numerous experts come before us on Zoom this session and tell us that the brain isn't fully developed until we reach 25 years old. We've had that on multiple bills across the board. And so when we're talking about children having access to their parents and having access to counsel, I think that that is absolutely critical. I do have a couple of questions, Mr. Chair. Mr. Kroll did say that, you know, this can easily be resolved with videotaping the situation. I'm not sure how videotaping the situation or videotaping the interrogation would resolve the issue, because you still would have a child not knowing their rights who could provide a false confession or provide information or say whatever they need to say to get out of the situation. So then you have that videotape. Okay, you can take the videotape, and I guess, you know, the child who somehow gets representation can take that videotape into court and then go through a parade of horribles to show that they did actually provide a false confession. So I'm not sure, and if someone could expound how you think videotaping the interrogation is helpful, I'm happy to hear that. I also will suggest that the Office of the Public Defender did testify today that they can absorb working on this, and they do have enough capacity, whether it's in person or on the phone or on Zoom or whatnot. So they are ready, willing, and able to take up this effort. And to the point that was made, what happens when the parent is a victim? And this certainly happens when the caregiver is a victim, you know, and that does happen. They still, I think, the child still has a right to consult. I believe the bill says, and Delegate Bartlett can correct me if I'm wrong, they have the opportunity to consult. So they might not have a parent there, they might not have a legal guardian there, but they would still have the opportunity to consult with an attorney so that they know their rights. So there were two questions kind of wrapped up in there. One about the video. And the other one is about if the parent is the victim or the legal guardian is the victim, what is your position? Because you're making a big deal about, well, they killed their parent. Okay, but they still have an opportunity to consult with an attorney. Are you for that? Are you against that? What's your position on that?
Thank you, Madam Vice Chair, for the question. I think what my colleague was saying in regards to filming interactions between juveniles and law enforcement, that would be helpful in determining whether or not waivers are done voluntarily, knowingly, and intelligently, specifically to that issue. As for—
But if not to cut you off just really quickly, but once you get to that point, you're still, you're teetering on the it's too late situation, because at that point, the child has already given, in the scenario that I'm providing, an involuntary confession that is also possibly false. And then, so what are the other steps that you have to go, that the child would have to go through with their attorney? Aren't there lots of other steps that they would have to take, and the process would be prolonged and they would be in custody? But I guess it's okay, so we still have this on video. And
I didn't say it was okay. I said the remedy of not having the confession come in is the remedy. Now, if there are further things that need to be done civilly to make sure that that sort of scenario is done again, I think there's a fundamental disagreement between us in that, can a juvenile ever waive? And if a Miranda warning is crafted that's age appropriate by the Court of Appeals, which is what our suggestion is, there would be occasions where a juvenile could waive and make a statement. And then a judge would have to determine whether or not that's voluntary or not. If you're going to stand from the position that each and every interaction between police and children that is going to be an interrogation has to be with a attorney involved, then there's really not going to be much of a need for Miranda at all, because every attorney is going to say, don't have a statement, don't talk to the police. So I think it's just coming from two fundamentally different places where we just disagree on. But in no way do we think that the current status quo is acceptable. I think that's been pretty evident from our comments. And we hope that we can work on a age-appropriate Miranda that's acceptable to the Court of Appeals, preferably drawn up by them, that would meet muster to satisfy the requirements of the Fifth Amendment and Miranda.
Thank you, Mr. Chair.
Delegate McComas, then Bartlett, Shetty, and Anderson so far.
Thank you, Mr. Chair. I just have a couple questions to kind of get some context here. We have the child advocacy centers that deal with child abuse and sex abuse, and it's usually a teen group that works on it. And they are all very well trained and skilled. And you have the detective, and you have the prosecutor, and you have the Department of Social Services, and and everybody has some pretty extensive training on how to deal with the children and with the different type of problems. So if you flip that over, and the children are helped if they want to testify against the abuser. They testify in court. Their testimony is given credibility. So on the reverse side, we have a situation where if a child says, I did it or I didn't do it, maybe to have something like that. But the point is in either situation, whether the child is the criminal or the child is the victim, the child is able, those statements are taken and used in court to either prosecute or to prosecute the child, or to prosecute the adult criminal that harmed the child. So in both situations, the child's statements are taken for truth. So, and of course, the child cannot testify unless they understand the repercussions of an oath. And they've had children testify as young as, I think, 7, 8, maybe younger than that in court, if they feel, if everybody is comfortable with the child being capable of testifying. So I guess I don't understand why we have such a great problem here, because a lot of the cases that the proponents of the bill are bringing up are all cases that happened many, many years ago. Okay, nothing that's that current. And I suspect that the standard now, as far as the standard of the police and how the best practices by the International Association of the Chiefs and the accreditation groups, they're probably much better than they were maybe 10, 15, 20 years ago. So I guess what I'm kind of wondering is are we really touching what the problem is, or are we making a problem? And I understand, because we're dealing with children and everybody's concerned about the age of 25, the brain is fully formed. Well, maybe we shouldn't prosecute anybody until they're age 25. I mean, come on, I guess.
Well, let me say this, Delegate McComas, if I may. There is a problem. And I told Delegate Bartlett, we agree upon that. So there is a problem. Let me emphasize that. I see Delegate Bartlett smiling, but we had a nice conversation together. And we came first to say, we understand there's a problem. So let me make it crystal clear. There is a problem that we need to address. And it's a problem whether it's Delegate Cardin's client, which I don't know how long ago that was, Delegate Cardin, but anytime a child is abused, it's one time too many. So do we have a problem? If there's just one, that's one too many, and we should resolve it.
Well, I guess my concern is that, we don't live in a perfect world. And we always use that, well, if one person's killed, that's one too many. If one person's abused, it's one too many. But we have an imperfect system, okay? And I mean, we got to be rational here. And I guess my concern is that, yes, we have to do better, but if you record these interrogations, that is, I think, one remedy. If the police officer has the body camera and when he's even just talking to the child, just, hi, what's your name? And that's going to help, because he's not going to grab him by the arm or the scruff of the neck and say, you little SOB, you tell me what you did, and shake him. So I just feel that we do have some remedies out there. And we can certainly do better, but I just to just kind of say, we need mom and dad, and we need the lawyer, and because quite honestly, the public defender's office has trouble as it is taking care of their actual clients, because they're short of staff. They're short of just secretarial staff. So I kind of have a fit. Kind of like, how's this all going to work, and how can we fix it without breaking the bank and just kind of upending everything?
I agree with you, Delegate McComas, and in response to the Vice Chair's question, I didn't touch on it. I think the public defenders who were testifying as proponents of the bill, in respect of my colleagues, were greatly underestimating the amount of commitment that they would have to do to make this bill into a reality. For example, say you had Delegate Cardin's situation where he's talking about 4 different suspects. The public defender would have to be provided for all 4 individually. And to say that it wouldn't be impactful fiscal note, and that, well, we're committed to doing it, so we're just going to do it, I don't think is being completely honest with the committee.
Delegate McComas, if I may observe on behalf of the Chiefs and Sheriffs Association, we are, as a whole, a lot better than we were 50 years ago, 30 years ago, even 10 years ago. I became a prosecutor in 1998, and our awareness of issues involving juveniles is leaps and bounds ahead of where it was before. We can always do better, we can always improve, and that's why we fully support Delegate Bartlett's desire to do just that. I have in front of me the IACP model practice for interrogating juveniles, and talks about things like open-ended questions. It talks about things about not flat out lying to a juvenile suspect. It talks about a more child-friendly Miranda. There are other things that we can do to make sure the interviews are proper. Senator Carter showed a video in the Senate side this morning of interrogation that was just this year. A 15-year-old is lying with his head on the table, and the officer is saying, "You get the right to remain silent," and kind of tosses the Miranda on there. That shouldn't happen. And I can tell you that if that happened in Sheriff Barry's office and I find out about it, that officer and sergeant coming to my office as soon as I see that video and we're having a talk about it. So we can always do better and always improve. And we very much want to work with Delegate Bartlett about ways to make the process better. When all is said and done, false confessions should not be happening. And what absolutely should not be happening is a false confession that leads to somebody's prosecution or incarceration. What do we do to prevent that? We follow IACP model policy about how to do the interrogation. We videotape the interrogation. It is not 100% perfect cure, to echo what Delegate Madam Vice Chair Atterbury said, but it goes a long way to showing us what happens and how to make things better. We also have tools available to us we did not have before. We have forensic testing that we simply didn't have even 20 years ago to try to prevent that from happening. So again, we share I hope we all share the goals here. The wellness question, really the only issue is what's the best and most efficient way to reach those goals?
Just a quick follow-up. When let's say a child does admit that they did it, there's usually other evidence that points that they did it, not just in other words, you guys just don't use the confession, do you? You make sure that, that they were at the scene, that there may be some DNA, that there may be, they're in possession of the stolen goods. I mean, in other words, you don't just rely on a confession and say, okay, the kid confessed and, we're going to get a guilty verdict and move on, right?
Absolutely.
All confessions must be corroborated by a mere scintilla of evidence. Otherwise, it's useless. I mean, if you had someone walk into a police station and not even a juvenile and say, I killed Jimmy Hoffa, that alone is not enough to convict somebody. That confession is not admissible. You need more evidence to do that. Any prosecutor, and I mean any prosecutor worth their salt, is going to want as much evidence as possible. No prosecutor is going to rely solely upon a confession because one, it just isn't enough. And number two, you have a hard time convincing a jury that's enough. So I share with that. Other evidence is always welcome and always looked for.
And in this case, we're talking about juveniles, so 99 times out of 100 wouldn't go to a jury. It wouldn't meet the mustard of a motion for judgment of acquittal at the juvenile hearing. Just a confession isn't enough. Absolutely.
All right. I have a question before I let Delegate Bartlett go. One of the issues that you've brought up a couple times has been the issue related to body cameras or having the interrogation filmed. I guess that it strikes me that while I'm not in any way saying that it shouldn't be filmed, but I think it misses the point of the bill in the sense that the issue isn't that the interrogation isn't going to be filmed. That happens all the time. The issue is what happens before they turn on the cameras, what happens before that time. And when the child is moved from wherever the crime may or may not have occurred or wherever they were to a place where the interrogation happened. And then we had in some of the previous panels, and those interrogations can happen in a lot of different places. So let me go first to the sort of the question of filming. Do you agree that, I don't think filming is necessarily solves all of these problems, right?
You are absolutely correct, Chair Clippinger, 100%. When we're limited with time constraints, we hit on highlights. And filming is one aspect of the entire scenario that we're talking about when we're talking about reforms that we would like to see made. And I look forward to working more with Mr. Pashnik and Mr. Spencer. I think was really impressive with his guidelines that he was talking about. We would like to be able to take those sorts of remedies and propose those to Delegate Bartlett as amendments to this bill. But as a collective, we're not saying that there's one tool that fixes everything. It is a part of the conglomerate of reforms that we think should happen.
All right, I have a couple more questions. I'll fire a couple of them out there, and then I'm going to yield to the rest because there's a line. I will say, I think that allowing the Court of Appeals to do the rules makes some sense to me. And I think that there's some general consensus that the Court of Appeals would be in a better position, the courts, to determine and use case law to determine what that age appropriate language would be. I don't know if we have written testimony from the courts. I'm sure I'll be hearing from them shortly. I guess the other questions I have to do with limiting custodial interrogation, or the definition of custodial interrogation to questioning that happens after an arrest. I'm kind of wondering, there's sort of a broader question of where do you draw the line? Because when we talked about this last year, and Mr. Potashnik raised this issue, and I raised the issue last year, and I've thought about it more since then. But where do you, I mean, there's an officer who walks up to a child on the street, and that child may not feel that they are free to leave. And we heard the testimony, especially in the last couple groups of the proponents of the bill, where those children absolutely don't feel free to leave, and because of the science that we know, they don't feel free to leave. So on the one hand, I think I hear Mr. Potashnik saying, well, this is going to cover a wide range of different interactions. I'm wondering whether there couldn't be language that spoke to maybe before transporting a child, maybe before handcuffing a child, but maybe before transporting a child. Seems like a little bit more reasonable, that then that would trigger the contact to parents and the contacting an attorney. I'd like your thoughts about that.
Mr. Chairman, so with that avenue, I don't think anyone has a problem with contacting parents. I think my problem lies, and I'll give you a real world situation that we encountered in Baltimore City when I prosecuted juveniles there and I was a chief there. We had a situation where we had a group of 15 youth who were alleged to have attacked 3 different people over the course of an hour and stolen cell phones, some medication from somebody who needed it, and some monies. That group was then stopped actually close to the Juvenile Justice Center. And at that point, the police needed to figure out who did what did who do I take in, who do I don't. Under the way this bill is drafted and what the scenario you are indicating, those children were stopped. I would fully believe that none of those children believed that they were free to leave. At that point, we'd have to get 15 separate attorneys on the phone within a short period of time before the police just decided, well, you know what, I think we're just going to arrest everybody and let it all figure out. So, there are some practical problems with that really aren't considered when you think of multiple people who are involved.
Really just, I mean, look, I think you call 15 parents, and then, I mean, well, and I think this is part of the challenge that I guess is still out there for Delegate Bartlett and for you all. And I am happy that everyone's talking to each other for you all to resolve. It strikes me that there's some part of that could be done relatively quickly. The 15 parents, probably. The attorney's part of it, I agree, is a little more challenging, but that getting back to the problem of whether the public defender has enough public defenders on call to go and help every one of these children whenever they were being interrogated. I guess the other thing regarding that just popped into my head, you may not need to interrogate all 15 of these kids. You may not necessarily be interrogating everybody. And that to me, I take the point, but I kind of wonder how often that happens. But I'll go to another issue and then I will shut up for a little while. But and I wrote it down here and now I have to remember. I guess the question also is about the scope of this. I think it's difficult to distinguish between whether the child is being charged as an adult or being charged as a child. And I think that these rules are going to be better and easier for police officers if they are clear that if it is a person under 18, these are the rules that you have to go forward with if there's if you're doing an interrogation. I do not believe that there needs to be a distinction between one or the other, but I kind of wanted to give you the opportunity to respond to that, because I believe that is something that's been thrown around out there, that maybe this should only apply to kids who are charged as adults. How can you make that distinction, especially kind of building on the argument that almost anything can be a custodial interrogation? How do you, if you don't even know what they're going to be charged with yet, how do you know whether you would be able to, whether you needed to call a parent or not, if that were the case? So
Delegate Clippinger, I'll be the one responsible for training our officers on any bill that comes out in the assembly. So I can tell you that some of these you're concerned about I agree with them. Custodial interrogation, the bill says retains judicially accepted meaning. And so we are constantly training our officers what that means. I honestly don't think that the custodial interrogation from the officer's perspective is going to be that more complicated under this bill and other versions of the bill. The fights go on in court all the time. No, my client was actually in custody. No, my client was stopped. No, my client didn't feel free to go. But from the officer's perspective, we try to give as clear guidance as we can on what it means to put somebody in custody, because we have to. Miranda applies when there's custodial interrogation, regardless of the age. It's custodial, they have to provide Miranda now. To your point about where lines get drawn, and as I've seen 11 different statutes, so if I'm looking forward to reading more, and lines are drawn in many different places. Some states draw the line at 16 or below 16. Connecticut, interestingly, has the way they do their statute, a statement obtained in violation of their statute is not admissible in a delinquency proceeding. So the admissibility is controlled by whether it's adult court or juvenile court. It doesn't impact the expectation on the officers. So there are many different ways to have that. There are many different ways to approach that, and there are reasonable discussions about where we draw lines, what guidance we give. So officers, I mean, you're right. There might be a situation where an officer is not really clear. Is this going to be a first-degree assault or a second-degree assault? And that might make a difference.
Right.
There might be situations also where an officer doesn't know for sure. Is this person 18 or 17? Because a lot of kids don't have IDs on them. So there's going to be a lot of gray areas, which we need to work through, and every police station is going to train their officers to deal with those gray areas. But part of the conversation we want to have with Delegate Bartlett is just where are we going to draw the lines? What do the lines look like? What makes sense?
If I could ask the chair, also, the Rules Committee is dealing with this, as we know right now.
Yeah.
The question is, although they're not elected and the legislature is elected, who's in the best method to pass these rules and regulations at this point in time? But they have brought it up from this point, and I'm not sure who is. I really can't say who. But the question is, somebody's going to make a rule change, and I'm not sure which is better at this time.
Well, I think we're probably better, so we'll see what we can do here. But having said that, well, I shouldn't say we're probably better. I'm selling us short. We're definitely better.
Okay.
I'll go back because Mr. Spencer opened up one last thing, and I promise to stop now. I mean, when you're training officers, you know, officers don't know what judicially the common judicial meaning of certain phrases are. You train them to do that. But having said that, I think some people have proposed that we kind of navigate and name specific cases in legislation and try to tie it into certain rulings in cases. Is it easier for you to train if you're just using the judicially recognized meaning in some of these cases? Because at least there you know, you don't have a whole lot of, I mean, you can determine what the judicial holding was in these cases.
So the training that I generally do is case-based. Okay, so we have a decision from the Supreme Court. JDB is a perfect example. When that case came out, I was in the state's attorney's office, and I provide the training to the sheriff's office about that case and what it meant. So the case provides a story, and officers, like every one of us, they remember stories. What lesson we learn from that story? What does that mean? And by exploring the different cases, we see plus and minus. Now, some things are obvious. If the person's in the back of your patrol car in handcuffs, taken to the police station, that's easy. We know that. We have another bright line. A typical traffic stop is not custody. It's not a custodial interrogation situation. That's easy. Some bright lines there. In the gray area is always going to be hard. It's also always very hard to expect an officer to remember the 10 cases that I told him about on the side of the road. But we go through the case law and work with the officer so they can get a feel where things come down. To your point, I saw there's a draft version that explicitly has JDB, for example, in the statute. I think it becomes problematic because if the Supreme Court decides to change the rules, well, then we're stuck with a statute that might conflict with new Supreme Court case law. When JDB is probably a good example. Until JDB was decided, for custody purposes, is an objectively reasonable person. Subjective conditions like age or intoxication didn't factor in that at all. But JDB came along and said, oh, no, you have to consider age in deciding whether somebody's actually in custody. So the Supreme Court, for that matter, the Court of Appeals can come up with new laws or crafting situations that might not mirror a case that's been codified in the statute.
Well, I to that point, I mean, I think, and as I was, rallying my committee against the judiciary a moment ago, I think a fairly safe-ish place to be is that the courts write case law, but we write the law, and so I get leery about bringing in specific cases into statute when we are doing these things. All right, I've held forth quite long enough. We'll go to Delegate Bartlett now.
Thank you, Mr. Chair, and I appreciate your questions. And yes, we have been meeting, we have been talking, and we will meet again. Sounds like I need to get everybody in the room at the same time. It seems like that's what we need to do now. I wanted, and Mr. Spencer, you brought it up a couple of times, the IACP training, excuse me, training. This is the International Chiefs of Police, I believe, is the organization. And you mentioned it, and the first sentence is in there. In fact, we had two of the experts who are listed in the book. That was Mr. Dreisen and Miss Laura Nereider were here to testify earlier. The first thing that was mentioned was the sentence is, overall, law enforcement is not adequately trained in interviewing and interrogating adults. So that's the first sentence of that training. So we know that we have a problem, just like you all said, we know that we have a problem. And as I said in our meeting with just us, I said, it's a problem we can fix. I know we can fix it. I feel very confident that we can fix it. In fact, we've been even talking about ways that we can work around, we can fix it. One is the parental notification. As you all have said, we don't have a problem with that. The other is the Court of Appeals, don't have a problem with that, doing the Miranda part. The part that we disagree on a little bit is this custody and custodial interrogation. But we don't disagree too much because we all agree that the Supreme Court is the supreme law of the land. So we know that, and we know that JDB has already put it in place. We know that Miranda is already in place. So now what we've got to do is figure out how to make Maryland law look the way it needs to look so that we can make this happen for our kids. With that said, I want to bring up one more thing, and then I'm going to put a question mark at the end of it, as I'm supposed to do. And that is with respect to the videos. With all due respect, the first video I saw with law enforcement in real life was the Rodney King video. And if I had bet all my money on that video, I would have said, I know how this case is going to turn out. And unfortunately, I would have been wrong. In the Senate hearing, and you all might have been there, and I know Mr. Spencer was because he referred to it, the defendant was recorded, and the defendant grunted, didn't say yes or no, grunted, and grunted, and never gave a clear indication that there was an understanding. What our bill wants to do, or intends to do, is to make sure that youth have a clear understanding, just like it is stated in JDB, where the child was not given his Miranda rights until after he had confessed. So we want to make sure that we codify exactly what the law is. And with that said, my question, because I have to put a question at the end of this, is when we meet again, first question is review this recording, okay? Because you guys have said some great things here. In fact, you've made my case on some issues, and I appreciate that. When we meet again, will we be able to talk about this? I have to make a question. That's my question. So, but really, thank you all for meeting with me and working with me. And I do believe we're going to get something written down and something codified so that we can help our kids. And thank you all for the work that you do. Isn't that so?
Yes.
I'll answer by saying yes, Delegate Bartlett. And to answer your question, it truly is a definition of custody. That's going to be our major work that we have to do. And we have to my things and do things like that, but I think we can do it. I told you that from the beginning. So we're trying to meet with you and work as hard as it is to get it done if we can.
Yep, we can get it done. Supreme Court's already done the hard part for us.
Okay. Delegate Shetty, then Delegate Anderson, then Delegate Conaway, then we might be done. Delegate Shetty.
Thank you so much, Mr. Chair, and thank you, Delegate Bartlett, for your work on this important issue. This question is for Sheriff Berry. I represent the district where one of the elementary school students who was described in earlier testimony lives. So he has an IEP. He brought play money onto the school bus, and he was interrogated by police without the notification of his family and without the presence of counsel. So I know, Sheriff, you mentioned that there are a number of model policies that are already in place. And I'm just curious if you know if these policies are in place in every jurisdiction in Maryland. I know you're the head of the Chiefs and Sheriffs Association, so I don't know if you happen to know offhand that information. And specifically whether that's in place where I serve in Montgomery County, because I'm really concerned about instances like these. Like, would that have followed the model policies that are referenced? And if not, let's say that the child did say something that put them at odds with the law. I don't think that that was the case here, but let's say, hypothetically speaking, model policies are in place. And let's say that a child makes a confession and the officer violates one of these best practices that have been mentioned. So would that confession still be admissible in court currently? I think it would be. And I think the reason that we need to be thinking about putting something like this in law is that these best practices don't have the same effect as law. So I'd love to hear your thoughts and comments, please.
Thank you, Delegate, for this opportunity to participate in this discussion. As we know, I think that we're trying to change the Police Training and Standards Commission. Right now, we are a best practices commission. We're not a regulatory nor statutory commission. So I think that the General Assembly members are moving in a direction where when we codify a particular policy, rule, or procedure, it's going to be the law of the land in Maryland. It seems that that's where we're going. Right now, the commission is just best practices. So to your point that there may be some people maybe following the IACP blueprint in reference to obtaining statements reference to juveniles, they may be following the policies and rules and procedures of CALEA. But all of those particular model policies, again, are following the law when it comes to Miranda. So you may have different verbiage, but they are following the law. So that's a question in reference to the General Assembly. Do we want to move towards to have the Police Training and Standards Commission be a regulatory or statutory organization? So that's a question that when we put out something in reference to how we go about dealing with juveniles, that policy will be codified across the state. It's just like the same conversation that we're having in reference to use of force policy created by the Police Training and Standards Commission. But getting to your specific point in reference to this school-age young man having some type of contraband or some type of
It was Monopoly money.
was it money? I didn't know what it was.
Monopoly money,
Okay,
like from the board game. Yeah.
Okay, so I don't know specific about that case, but as you already know, any information that is gleaned in reference to a police contact, police will document it. They will put this individual statements in there. And again, before anything moves forward, as you already know, I'm pretty sure that didn't make the desk of our state's attorney here in Charles County. It probably was taken care of in Department of Juvenile Services or that matter, or disposed of, not going to the court system. But to your point, if we're looking at the overall issue in reference to criminality and statements, and it gets to where you're talking about adjudicating it through a court process, you know just as well as I do that the state's attorney looks at those statements. They, of course, it's vetted through looking at the age of the juvenile, as looking at the characteristics of the juvenile, and all the other things that goes into and seeing that statement is going to be admissible. So again, we're following those particular laws in reference to that. So again, getting back to that point, policy, commission is best practices. We're not statutory nor regulatory. So we have to get across that bridge. And to that specific incident, if you have more details, I would love to be able to research that and see if our staff member fell short in reference to training and expectations as me as a leader of this organization.
Thank you so much.
Thank you. We'll now go to the Quite Honorable Delegate Anderson.
Thank you, Mr. Chairman. And I appreciate all the questions that have occurred before. I have some questions based upon what the chairman has asked and some of the statements made by the state's attorneys. It's funny, in this bill, I would have expected at least the state's attorneys to come forward with a more substantial or at least substantive argument against the bill. Your arguments kind of seemed a little bit more procedural or fiscal, as opposed to specific arguments as to why we can't do this in terms of policing or completing cases in the state's attorney's office. So I thought maybe we should narrow this down and try to find out exactly how large a problem it is. And I'm gonna go to Gavin because I've been dealing with you, more closely for the last couple of years. In your county now, Harford County, what would you say was the number of juveniles that were arrested in 2020? Ballpark. You don't have to give me exact figures, but you've been long enough to get an idea as to what your department is doing.
Low. I don't have an exact figure for you.
Okay, I'll just talk.
It goes down every year. The Department of Juvenile Services has a chart that they do. They have the statistics. Those arrests decrease every year. I'll tell you that.
Okay, so would it surprise you? I just talked to the Department of Juvenile Services while we were having the discussion. They indicated that Harford County had a total of 455 juvenile complaints last year.
That would not.
My question to you is, of those 455, say again?
That would not surprise me.
Get it. Of those 455, how many do you think, and again, given your experience as a state's attorney and knowing your county now, of those 455, how do you think you actually interrogated while in custody? What percentage?
I cannot answer that question unless I actually go through and look how many. We get complaints from citizens. We get complaints from police. We get complaints from outside sources.
Okay, 95% of your complaints last year were from the police.
And I do not know. I couldn't answer that question for you.
Okay. there's an estimate that generally about 15% of all arrests, whether they're juvenile arrest or adult arrests, end up needing custodial interrogations where the officers need more information about a case. If that's true, we're saying maybe in Harford County, talking 45 juveniles throughout the year that would need the assistance of an attorney during this investigation, which means the problem is not as large as we might think it is. Would you accept that premise?
Delegate Anderson, again, I don't know. And I think from my testimony, part of the problem I have is the administration of this particular program. And there doesn't seem to be a plan. It's very well that there could be not a whole lot of custodial interrogations that require the need of the attorney like you talk about. There also could be a lot more instances where there is an interrogation that is custodial, but is never challenged in court. To be fair, I really couldn't answer that question about how many would require the use of this particular statute. But I would anticipate that in a lot of situations where you have multiple juveniles in one particular incident, you're going to require multiple attorneys to handle the influx of that. And how you parcel out conflicts, how you parcel out who gets paid, how you parcel out the administration of the program is part of the issue that I haven't seen yet. And again, these things can be talked out. As we've all indicated, we're all willing to work with the sponsor and others to talk out much of this. But to get to your point, I'm not sure that I can, in Harford County, express the, as you call it, the scope of the issue, which could be high or it could be low with those 400 arrests.
Well, that's part of what I'm trying to find out is what the scope of the issue is. And in Harford County, there were 455 complaints last year. In Baltimore City, there were 1,000. In the entire state of Maryland, there were a total of 15,000, which would seem to me that the scope of this problem is not, probably would not exceed the abilities of the Office of the Public Defender to provide attorneys or to have attorneys, as the chairman had said, on call when there was a need for custodial interrogation.
That is again, we can agree to disagree. I think that the cost for that would be higher than I think people realize. And what I would hope would be some sort of plan from the public defender. I would hope that they would have provided a plan to us, to you, to somebody to explain how they would administer this program.
So if that plan were to come forward and it was some reasonable fiscal accommodation, would that obviate your opposition to this bill?
That would obviate my opposition with respect to that portion of the bill. And again, the opposition is not a total opposition. We all agree that something needs to be done. I think how you administer this, how you go about making sure that people have a Miranda, how you make sure that you comply with JBD North Carolina are all issues that I think we can talk and discuss. I think if we look at in custody and we limit that in custody, or we apply it to the conditions that are in JBD, we have language to that effect, I think that may more than likely obviate the fiscal requirement of this, because you would have a clear indication of what that would encompass.
Right.
I also like to add, I think I saw the delegates' questions during the proponents of this bill, and I thought the delegate was much more concerned about the requirements of just, rather than just an on-call attorney, that an on-call attorney wouldn't be sufficient. I was really impressed by your questions of the proponents of this bill when that part of the testimony came up, that you didn't think that simply having an on-call attorney would be a sufficient and meaningful representation.
Okay. And Caroline County, by the way, had about a third of what Harford County had in terms of complaints filed. And again, I know that the Office of the Public Defender I personally believe having practice in your county, think that the Office of the Public Defender would be already equipped to handle that within their existing budget.
The aspect that you were talking about when you were questioning proponents to give the meaningful type of representation that you were talking about then, I'm not sure. If you're talking about just an on-call attorney that can pick up the phone and say, don't talk to the police, probably. But I thought your proponent, when you're asking questions to the proponents, you were looking for much more meaningful representation.
Well, I think we've come into the point these days that we can have an on-call attorney that's virtually there for the entire, and the chairman made me think of this, is that we could have the attorney there for the entire custodial interrogation. That way, the child, there's no need to advise the child whether or not you want to have an attorney, just have him there. But anyway, we'll discuss that. Thank you, Mr. Chairman.
Thank you very much. We're joined by Delegate McComas's cat. Delegate Conaway for what might be the last question of the afternoon. Delegate Conaway.
Thank you, Mr. Chairman. Thank you, Judiciary Committee. Thank you, panel, for coming in to testify. My question is, can a juvenile, a minor, consent to an audio video interview? In other words, can they enter into a contract to have an audio and video taken of them in the state of Maryland? Anybody can answer that?
I'm a little bit unclear how a minor could enter into any contract with the police. The police have
So then if you Mirandize the minor, then they still can't give their consent to giving you a statement. Is that correct?
I'm a little bit unsure about that question.
Right. So if you say we can talk this out, and if the person that you're interviewing, the juvenile, is a minor, let's say it's my child, and I object to you interviewing the child, would the whole interview be thrown out? If the police say, well, he's 16 or she's 16, and we think that they can be interviewed, and I said, no, they're a minor, and in my eyesight, no, I'm their parent, I want it thrown out. Will it be thrown out?
That will be up to a court of law, but any statement given must be voluntary in nature. And
that's my question. Can my juvenile 9, 10, 11-year-old child give a voluntary statement legally?
I encourage any law enforcement officer that wanted to interrogate your child to contact you if we're talking about a custodial interrogation. And if you told your child what you're saying now, I would assume that your child would not make a statement to the police.
Well, I would think that my child would think that Officer Friendly is their friend, and not thinking that the officer might be trying to bait them into some kind of confession. What about that side of the story?
I still think your child would listen to you because you're their father, knowing you that your child would listen to you.
Okay, thank you very much.
Sure.
Okay. I think those are all the questions that we're going to have here. It's 5:30 just about. Seeing no further questions, that concludes the testimony on House Bill 315. Thank you all for speaking with us this afternoon, and thank members of the committee. We will be having a voting session tomorrow, 3 p.m. tomorrow on Friday. If you haven't got your amendments in, I think they needed to be here 2 hours ago. If there are any amendments, I'm not sure that there are. Anyway, thank you all very much and have a very, very good evening. Good evening, everybody.